Good morning. Welcome to Stringer LLP's 36th Annual Conference. We are presenting this year by webcast from downtown Toronto. We have with us a live small audience. For those of you who are joining us remotely, if you hear heckling, laughter, shouting, you'll know it's from the people attending live. It's a small group, so hopefully they won't be too rowdy. This year we have about 300 people joining us remotely from all corners of North America. So for our American friends, welcome. Those in other jurisdictions outside Ontario, welcome as well. And of course, for those of you closer to home, glad you could join us. And we have a very wide and eclectic range of people joining us, from not-for-profit to charities, to for-profit, private sector, industrial, information technology, medical science, you name it, a very wide range of employers joining us today. Like all years, we have a Q&A session, which is often the most exciting portion of our program. And like last year, we will be reserving the last 10 minutes or so of our sessions for Q&A. So at the end of every session, there should be about 10, maybe 15 minutes, depending, for questions. For those of you joining us remotely, at the bottom of your Zoom box, you should see a box for Q&A. If you click on that, you can type in your questions. And we'll do our best to answer them all, but unfortunately, we may not get to every single question. So please forgive us if we don't. And if you're joining us remotely, feel free to shoot us an email if you like, and we'll do our best to answer them if we don't get to them today. As usual, we value your feedback on our program. At the end of the day, you'll be receiving a link to the evaluation forms, and we ask that you complete those. And a little bonus, if you do complete the feedback and give us your views on the program, you will then receive a link to download electronic copies of today's slides. So you'll have all of those for your records. And for those of you who are HRPA members, this program is eligible for 5.25 CPD credit hours with the HRPA. Now for us, in order to authorize those, we need to, as part of our agreement with HRPA, we need to confirm that you've attended. So to do that, we would ask that you go into the chat section and just make a comment with your email to confirm your attendance. So just type in your name and your email, and you will have, they will know that you're attending. And a little bit of excitement will be coming later on today. I don't want to give away too much information, but it's got something to do with our website. So stay tuned. We should have more information around lunchtime. So I would like to present our first speaker, Alison Taylor. Alison is one of Ontario's leading employment litigators. She is in the courts regularly. So when she talks about what happens in court, she knows what she's talking about. And she will be explaining the latest on termination clauses, because there's been a lot happening in the courts. So over to you, Alison. And by the way, Alison is presenting from her home. She's a little bit under the weather, but well enough, fortunately, to join us. So if you're wondering why you see a different background, that's why. Over to you, Alison.
Good morning, everyone. I was just really looking forward to seeing you all today, but I thought you wouldn't appreciate me coughing on you with whatever virus I happen to have. So I hope you'll bear with me if my voice kind of wobbles a little bit. So, we've been talking about termination clauses on and off for well over 10 years, as there has been a flurry of litigation over that period of time regarding whether it's really possible or not to craft a termination clause that will withstand scrutiny. And it's been a battle, if you like, between the courts and lawyers, or maybe we could call it a dance, of strategizing about exactly how to go about writing things well enough to pass muster, and so on. And that my talk today really indicates that is continuing in the current years related to cases which are the result of the fallout of the Waxdale case, which, as you know, came down in 2020, related to the question of the just cause clause in employment agreements and how that affects not-for-cause terminations. And really what the upshot of all of this case law has been is how much it's important from a court's point of view that the agreement be read as a whole, the way that an employee would read it, in other words. This is very much looking at things from the employee's perspective and saying, how would an employee look at this? They would look at termination as an entirety, and therefore that's how an employment contract should be read. And also what's very clear from this case law is that if you don't do it right, the court will just not give you any leeway. And that's really what I want to talk about first. And of course, we know that if you have a termination clause, the more normal reason for having one is to lighten the load of cost on termination. That is to reduce what you have to pay. Unfortunately, of course, if the clause is void for whatever set of reasons, the common law applies, and that's always a more costly alternative. So the first case I want to talk to you about is Raman and Cannon Design, which is a Court of Appeal case from 2022. It's a Court of Appeal decision of a ruling by the Superior Court of Justice on motion related to it's a summary judgment motion related to the termination of an individual with an employment agreement of the normal ESA type. And at issue here was the fact that we were not dealing with a garden variety employee. We were dealing here with an executive employee, a sophisticated employee, an employee who everyone knew had had legal advice before signing the employment agreement. So I just want to remind you of the case of Waxdale and what it stands for, just before we talk about the Raman case. It's very clear, unfortunately, that the phrase just cause in employment agreements is a loaded gun, and it just goes, it's a bomb, and it goes off. And the reason it goes off is because that clause really violates the Employment Standards Act. Now, it's interesting that the language in other provinces is quite different. In other provinces, just cause is actually used as the basis for disentitling employees from payments under employment standards legislation. But in Ontario, the legislature in its wisdom has seen fit to use the phrase willful misconduct, disobedience, or willful neglect of duty language instead. And it's clear that in some cases you can have just causes at common law. For example, matters that the employee's been warned about in writing would lead to termination, which don't amount to willful misconduct, disobedience, or willful neglect of duty. So in a situation where you use the phrase just cause as a disentitlement, you're disentitling people whom the ESA would not disentitle automatically. So in the Waxdale case, there was a clause of this nature. And the importance of the decision is that although the clauses are separate clauses, one for cause, one for not, if the just cause clause is void for the reason I've just described, it takes down the not for cause clause with it. Because what the courts have said, and they've been saying this over time, is that termination clauses, even if divided into pieces, are really one. They're one clause, and if any part of it is void, then the common law applies. Now, this has always been interesting to me because I've kind of wondered whether if there's something wrong with the resignation clause, for example, if that's all part of that whole how does termination come about type of clause. Does a problem with a resignation clause have the same effect? We don't know yet. Interesting concept, though, because all of this kind of ending of employment stuff really is viewed as one clause. And so in Waxdale, the clause, the ESA termination clause might well have been fine by itself. The cause clause was void. it brought down the whole thing. So Raman is kind of a variation on a theme, but it's a variation on a theme with a very specific plaintiff. Raman was hired in 2016 in an executive position. So she's a senior person in the employer's organization. She was subject to both an employment agreement and an officer agreement. So she's an officer of the corporation. And interestingly, the officer agreement was with a related company. In other words, she was working for a subsidiary, but she's got an officer agreement with a parent company. And there are three companies that are involved in this relationship with Raman. And I'll talk about that in a little while, because that is also something that is an interesting development out of this case. So canon suggests that Raman receive independent legal advice. Not surprisingly, because of the senior level she's at, she gets the independent legal advice and she signs the agreement. And 4 years later, she's terminated without cause. Now, I should just mention that the fact that she got legal advice does not necessarily mean that the legal advice would be, this contract is void and let's tell the employer about it. Most of the time, if the employment agreement is void in the employee's lawyer's view, they're not going to tell the employer about it. Why would they? Because they want to trade on it being void later. But in any event, she had legal advice, and the intention clearly from the clause was that Raman be terminable on minimal notice, ESA notice. That is always the intention. So there's no question but that, given that these parties are both sophisticated, their mutual intention was that the agreement be terminated on this minimal notice provided by law. So Raman is terminated in 2020 without cause. And again, of course, the agreement contains, as it would in 2016, because this is some time before the Waxdale argument started to be made, that the organization had the right to terminate employment at any time without notice or payment in lieu thereof if you engage in conduct which constitutes just cause for summary dismissal. So again, there's a Waxdale type of clause in this agreement. Now, of course, relying on Waxdale, Raman sued for common law notice, and she brought a motion, as people always do in these cases, for summary judgment, meaning they don't have to go all the way to trial. They do a paper trial, if you like, using affidavit evidence in a motions court before a judge. The other thing she did, and it's not clear entirely to me why she did this, although maybe there was some concern about solvency. She also sued for a declaration that all three companies in the corporate group were her employers. Now, it may be that, as I say, there was some concern that one of them was insolvent or teetering or something. It's not clear from the decisions. It may be that this was just the lawyer being thorough. In other words, there's documentation from three different companies related to her employment, the lawyer's being thorough. So the lawyer says, okay, we're going to sue everybody. So part of what was sued for here and asked for in the summary judgment motion was a declaration that all three companies in the corporate group were employers. And again, of course, Raman relies on the just cause and Waxdale clause. Now, the motions judge was very much influenced clearly, and keep in mind that in summary judgment, there are affidavits being filed by both parties. So the motions judge has a very clear sense of Ms. Raman as being a sophisticated person. And it's also clear that this just cause clause is what you might call a technical breach. I mean, you know, the not for cause clause here was itself not the issue. And there's a clear understanding, I think, generally, that if you do something bad, you don't get any money on termination. That's what we might mean by a technical breach. That is to say, the wrong language is used in just cause, but nonetheless, the idea, the subjective intent is clear. So the motions judge, in reading all of this material, and I should also mention that in the material, the company was quite forthcoming about the fact that Raman had connections with all of these three companies one way or another in an operational way as part of her duties and responsibilities. So from the material, the judge was pretty clear that the subjective intention of Cannon and Ms. Rahman was that on termination without cause, the ESA amounts only would be provided to her. That was a mutual intention since she had had legal advice. And the court says she's got experience and sophistication. She has legal advice before signing to explain to her what the clause means. And that's key, right? Because a lot of the time employees don't have someone to explain to them what the clause means. She does. Therefore, it's their mutual subjective intent to have short notice under the ESA, and therefore that should be enforced because that's what the parties intend mutually. And normally, what the whole point of a contract is that that's what the parties are mutually agreeing to do. And the motion judge, notwithstanding the evidence of these connections with these other companies operationally, also rejected the idea that all three companies were a common employer. And the judge said, look, not interested in that. One company offered to employ her. There's one letterhead with an offer of employment. One company paid her. That's the employer. And just being part of a group, a corporate group, should not lead to a common employer finding. So far, so good. When this decision came out, we're all happy as an employment bar because we think, okay, it's really just unsophisticated people without legal advice for whom these ESA clauses will fall. But for sophisticated employees with legal advice, maybe they won't fall. And therefore, we're happy. We have a way of defending these cases going forward. But unfortunately, it seems to happen a lot these days. The Court of Appeal decides to weigh in and says, no, you're completely wrong about that. So regrettably, the Court of Appeal found that the motion judge had erred in enforcing the employment agreement. And the court says, look, if we're going to decide whether this is a contravention of the Employment Standards Act, we just look at the termination clause, the words, we interpret the words, and we are not interested in subjective circumstances, external circumstances. We don't care who the employee is, how sophisticated they are. They could have written the Employment Standards Act. It wouldn't have helped here. We only look at the words of the agreement. And that means that negotiations before the agreement, subjective expressions of intent, subsequent conduct of the parties on termination, what they actually do when the termination happens, none of that helps if the wording is void. So it's really very simple. The wording governs. The wording is king. So the fact that the parties had done this negotiation, the fact that she had legal advice, the fact that she's a sophisticated businesswoman, on the face of it, none of that matters. This case is no different from Waxdale. Just cause there brought the cause, not for cause clause down. Same thing happens here. Now, this is really an interesting concept. It really dates back to the beginnings of these discussions with McTinger and Hodge in 1992. That's the initial case which talks about termination clauses being void for breaching the ESA. And at that time, it was a 30-day clause that was at issue. And of course, we know that if a clause is ever void, ever going to be void, even if it's not void for the actual termination itself, but if it can ever be void, then it's void. So a 30-day clause by definition is void because eventually it will be void once you get past 4 weeks under the ESA. So at that time, also the argument was, and it's a similar kind of argument, well, the party's subjective intent is that termination be done on minimal notice. So if we breach the ESA, the ESA, the common law should still be minimal to reflect that subjective intention. And the court said, no. We're not interested in your subjective intention. If you're void, you're void. If you're void, you go into common law. And the fact that you had some subjective intention or other has no impact. So again, the court is really saying, look, you just have to do it right, or you go to common law. Common law is the default position. And on the common employer issue, the Court of Appeal also did not agree. Not surprisingly, I think, in this case, because so much evidence had been filed to show how interrelated these companies were. They had common branding and association on their letterhead and company websites. In other words, they didn't treat one another as though they were separate businesses. No. They were completely interwoven publicly. They had the supervisory relations and meetings existed, which intertwined companies. Very common phenomenon with parent companies and subsidiaries, where there are often these kinds of cross-border and cross-company supervisory relationships and people meeting with one another because their goals corporately are the same, and a common bonus pool. And for any of you with American parent companies, this will all sound pretty familiar. This is the common pattern. So in this situation, the court said, there are all of these interrelationships. This person is essentially performing services. The company is presenting itself as a group of companies. Hey, presto, we have liability for all of the companies in the group for termination. Now, in this case, it may not have mattered because in the end, the employer, which had been the payor, if it loses this case, it'll end up paying her. It matters, though, if that company were, for example, insolvent and the employee is looking to the other companies to pay the freight on this particular case. There are other ways to get to that beyond this argument, but nonetheless, it's very clear that when you run a group of companies, you have to expect that they will all have liability for the terminations of employees, at least like her who have these cross-company relationships. So again, Raman makes your heart sink as a lawyer because it looks as though at the summary judgment level that with sophisticated employees, maybe we have a way out, and the Court of Appeal bursts that balloon and says, no, you don't. You either do it right or suffer the consequences. Who the employee is just doesn't matter. Now, a technical breach is the same argument that employers have made when their clauses have said things like, we can give you notice or pay in lieu and forget to mention benefits continuance. And then they argue, well, we continued benefits anyway after termination. So this is just a wording issue, but it doesn't reflect what we actually did. Again, the court says, don't care. It doesn't matter that you provided the benefits. A breach is a breach. You contracted incorrectly, therefore you've breached the ESA and common law immediately applies. So what we have to take from this is that the Waxdale effect, if we can call it that, will apply really to all employees who are in this situation. If you've got a just cause or cause even clause in your employment agreement, it's going to void your other termination clause without any question. So what do we do as employers to try and deal with this? First of all, let's find out, look at your templates and see what they say about cause. All old employment agreements say the same kinds of things because we've been writing them this way. Certainly as long as I've been in practice, it's been written this way until recently. All of these clauses say the same thing. It's short and sweet and ubiquitous. So the first thing to do is to make sure that it's not there anymore and have that wording revised going forward. This is on your templates for current hiring so that you can at least stop the risk of this applying in the future. For existing employees, we have to consider whether to try to amend their employment agreements to fix this clause. In order to do that, you have to give the employee something new, money, more vacation, something of value in return. And you've got to explain kind of why you're doing this because you can't really pull the wool over their eyes. Otherwise, the court will take a bit of a dim view of it. And you have to keep in mind that these employees have absolutely no reason to agree. I mean, why would they? If their clause is going to be void and you ever terminate them, they're going to get common law notice. So why would they agree to allow you to fix it? Unless you were giving them something that's so valuable now that they were willing to take the chance that they'll never be terminated. Nonetheless, if you've got a short service workforce, there are ways perhaps of doing this, and you could explore that with your counsel if you're interested in looking at that. Now, the second, and I confess this has been a bit of a concern of mine for some time, is the extra termination clause problem. And that is that some employment agreements, as a result of I think a wish to express the seriousness with which an employer takes particular conduct contain termination language in places other than in the termination clause. The most common example of this, of course, is probation. It's not uncommon to have a clause in an agreement that is just the probation clause. And it doesn't only always say you are on probation for the first 3 months. Sometimes it says that, of course, and that's fine. But sometimes it says, and if we terminate you, this is all we have to do. And that's effectively a termination clause. And that means that if you happen to do that wrong in some way, then it could have an effect on the other termination clauses. So that's effectively a situation that I think really needs to be remedied so that all of termination is in one place. But the other situation is clauses which say, if you do various naughty things, we will fire you. And I've seen lots of agreements like this over the years, generally related to things that are particularly heinous, like breach of confidentiality, for example, or breach of codes of conduct, this kind of thing, where the employer feels very, very strongly about this issue and has built in language about termination into the clause that deals with these particular covenants to respect confidentiality or to respect codes of conduct or whatever. So this is a bad idea for a couple of reasons. Firstly, it may contradict what your other termination clauses say. In other words, if nobody is checked to see whether these things match, maybe they don't match. And if they don't match, there's an ambiguity. If there's an ambiguity, the whole thing falls. And of course, the other is the thing we're talking about today, which is breaching the Employment Standards Act. Does this clause breach the Employment Standards Act? And if it does, based on Waxdale, it's a termination clause, it's void, all the termination clauses are void. And this is what's happened in this case of Henderson and Slavkin. In this case, a plaintiff receptionist was asked by employer dental surgeons. I have to say, I've had lots of dental office cases over the years. So this is a particularly risky kind of employment environment in terms of contracts and liabilities for long service employees. So in 2015, she's asked by the dentist to sign a new employment contract, and she was given fresh consideration for doing so. The termination clause limited her entitlements on termination to ESA only, which would kind of suggest that maybe she didn't have legal advice, because why would she sign this thing? But nonetheless, maybe the consideration was good enough that she was willing to take money now. I'll gladly pay you Tuesday for a hamburger today, sort of thing. In other words, I'll take the benefit now and I'll worry about the consequences later. After 30 years of service, so of course, at the time this is happening, she has 25 years of service. So getting her to sign this agreement, you can understand why the dentist wanted to do it and why they were careful to do it with fresh consideration. Nonetheless, this is a bit of a disaster waiting to happen. After 30 years of service, the employee is terminated in April of 2020. Now, this new contract that she signed, apart from this ESA only clause, contained a clause that stated that breach of confidentiality or conflict of interest would be cause for termination without notice or compensation in lieu. So these dentists, because they have patients, and that means they have patient records, take this situation very, very seriously, and they wanted to express how seriously they took it. Now, in this particular case, the termination clause is void. And that by itself would be sufficient to be a problem. But there's this issue of the secondary clause is also a problem, and the court also speaks to that. And it says that this secondary clause about termination of breach of confidentiality and conflict of interest is broader than willful misconduct, disobedience, or willful neglect of duty under the ESA. Why? Not surprisingly, because of the possibility that a person could breach confidentiality accidentally, that it could be very trivial, that the conflict of interest could be very trivial. In other words, that what the actual facts are just not worthy of what they call the capital punishment in the employment world, which is termination without being paid anything. And so the court says this is ambiguous. I can't tell, and the employee can't tell, if a very tiny breach of confidentiality is going to end up terminating them with no money. And so because of this, this clause then had the effect of voiding the termination clause as well. And hey presto, there's no termination clause, and the employee is right back to where they were before these clever dentists decided to have a new contract of employment, which is 30 years of service. As it turns out, the parties after this decision agree that the termination clause is, the appropriate termination notice period is 18 months. She didn't properly mitigate, that gets knocked down by 3 months, and so that they end up paying her for 15 months. But it was an exercise in futility because they built in this additional level of concern about confidentiality, which led them to put in this termination result into that clause. So the court said an employee is entitled to know at the beginning what their entitlement will be at the end of their employment and how and when it may be terminated without cause. In this case, it is not clear in what circumstances disclosure of confidential information may occur without immediate termination for cause without notice. In other words, there's just a lack of clarity about the seriousness which will lead to this result. The employee doesn't have any way of knowing that or measuring that. Therefore, the clause is void, common law applies. So employers often do build in this kind of remedy into these kinds of clauses because they feel very strongly that some things deserve the capital punishment in the employment world, that is termination for cause. But, I may have said to some of you, less is more when it comes to contracts, and this is a perfect example. This is overkill. There is no benefit at all to talking about termination anywhere in the agreement other than in the termination clause. There is no benefit at all to trying to send a message when the message may come back to bite you. So you can convey seriousness, the seriousness with which you take something in language in the agreement without talking about consequences. And that's the key thing. And that is the thing you should look for in your agreements. So lessons for employers, again, take out termination language that's not in the actual termination clause in favor of a single place where everything about termination is discussed. That includes probation. I think it makes sense to perhaps talk about you are on probation for the first 3 months when you talk about the person being hired, but nothing more. And then when you talk about termination for probationary employees, work that into the termination clause. If it's fine to emphasize that confidentiality, codes of conduct, and that kind of thing are important. You can add all kinds of language. It's a free country and you can say whatever you like in terms of your freedom of contract. You can say whatever you like about these things within the parameters set by the court about what's legal on termination. So if you want to emphasize that, you can emphasize that, but no specific consequences. And again, for existing employees, where this exists, what do? Again, offer fresh consideration, revise the agreement, see if they'll do it. If that's all you're changing, then it may seem fairly innocuous. But again, how do you do this without disclosing why you're doing it? And if you did disclose that, the employees would have no reason to agree. So, for existing employees, this is a very, very tricky thing to do. And of course, you never, ever want to be correcting a problem with a contract, offering a new one, giving fresh consideration, the employee signs, and then you immediately fire the employee because that's going to look like bad faith. So, options for termination clauses. I think it's important that we kind of go back to first principles here. What are your options? You can have one clause that provides ESA minimum in all circumstances. In other words, you just don't care whether there's willful misconduct or not. If you have to terminate somebody, there's one standard, and that's it. And that can be a solution because you just don't want to go down this road. Or you could have a clause that says ESA only, but you work in the words like if any to denote the fact that you're going to let the ESA machinery govern. And that hopefully will mean that the clause isn't void because it's not in compliance with the ESA. So that's an option. You can have two clauses one which gives ESA only for willful misconduct, etc., and one which gives something better than that where it doesn't exist. So in other words, the cause clause is no longer void, and your other clause may be less than common law, but it can't be brought down because your cause clause is no longer void. You can have two clauses still, one for cause, one without, and just change the language that you no longer use cause or just clause. You talk about willful misconduct, etc., as in to the extent provided under the Employment Standards Act, something along those lines. You cannot use except as provided under the Employment Standards Act because the court has already ruled on that being ambiguous. So you have to do something better than just add that kind of language. Or you can give up on the whole exercise and just decide you're going to rely on the common law. And there's certainly lots of employers around who just don't bother putting forward termination clauses or negotiating termination clauses. They prefer to just take the view that they'll take their lumps if and when termination happens. And a lot may depend on how much terminating you do. If there's a lot of turnover in that regard, then you have more of a concern. If your workforce is very stable, very loyal, then you may say, well, if we have to terminate every now and then and pay somebody 18 months, we don't care. We'd rather not talk about termination in the way that people would rather not talk about divorce when they're getting married. So those are some of your options. So I just want us to end with one other small comment, because this all sounds like such bad news that you just basically can't do anything, or at least you can't, the courts are really being very clear that you have to do it perfectly right or it fails. And that is the fact that the pandemic does not automatically lengthen notice periods. This has come out in a new case called Gracias and Dr. Walt Dentistry. Again, a dentist, don't know why. Everybody is asserting that they should get longer notice periods if terminated during the pandemic because of the pandemic. And the court has said, no, not automatically. It's an individualized case-by-case basis. In this case, the evidence, and it's important that there be evidence-led, was that the job market in the employee's profession was strong. Therefore, she was not entitled to a longer notice period due to COVID. This is in conformity with earlier case law in Yee and Hudson Bay Company. In a different case, Takis and Peninsula Employment Services back in February 2021, the notice period was extended and the court didn't really explain why, except to kind of vaguely talk about age and the pandemic. So what's clear is that you need to put forward evidence about job availability in order to defeat this. But if you do, it means that you're not automatically on the hook for a lot more money, the way plaintiffs' lawyers would like to suggest. And that is it for me, and I'd be very happy to take any questions you might have.
So, Alex, if you could just give me the thumbs up that I can be heard by everyone. Thank you very much. Allison, that was a fantastic presentation. I don't even mind that you went a few minutes over. We do have a limited amount of time for the Q&A now. So it is 9:38. We do like to finish at 9:45 as per the agenda. I don't yet see any questions in the online format, and we're just collecting any live questions there may be. So Allison, I had a question as I was listening to you talk about sort of the dilemma that employers with long-standing existing employees on bad contracts will face. And do you have any recommendations for how to tackle that? Is there a positive obligation to be entirely forthcoming about the reasons for the agreement, or do you just have to answer questions if they come and ask you why you're doing this? How does that work?
Well, I think the problem is that courts will always say to an employer, if they think the employer has done something dishonorable, that you are the party with the greater amount of knowledge, and therefore you really shouldn't kind of benefit from that without sharing information. In the same way that in many situations, if you're applying for benefits, for example, the court will say, an employer has a positive obligation to tell the employee what to do, how to go about applying for benefits. It's not good enough to just say, well, you can go and find out for yourself kind of thing. So I mean, if the court thinks that what has happened is unjust, it'll find a way to avoid it. And so, unless you are providing such a significant benefit that the employee now. So if you say to somebody, I need to change your contract and I'll give you $2,000 right now to do this, but just so this will affect your entitlement later on. The employer may say, well, I'd really rather have the $2,000 right now. So, and that's fair. And so away they go. If the employee, and the employee may say, well, I'll take the $2,000 now and argue about it later. That can happen. So, but I'm a bit pessimistic because, the courts do impress a duty on employers not to be sneaky. And so it concerns me that if you say, I just want to tweak your termination clause a little bit, nothing to worry about. And here's $25 for doing it. In theory, that should work. But we know that the courts don't tend to view employment contracts the way they view other contracts. They view employees as vulnerable. Yeah. So.
I like that. We do have an interesting question here, which I think comes up fairly often. You spoke about extra termination clause pitfalls. And so this question is about sort of subsequent policies and handbooks and how those documents, sometimes I guess, it's not in the question, but sometimes those are referenced in a contract and sometimes they're not. So if those extra termination clauses for violations of policies and whatnot are found in these extraneous policies and documents, does that have any impact on the analysis here?
I would certainly give them the axe. I think I did have a case once where the contract said one thing, the policy manual said something else. There was a reference to the policy manual in the contract. This created an ambiguity, and hey presto, we're in trouble. There's a termination provision in a handbook, unless you incorporate the whole handbook by reference into the contract, is not binding on the employee or on a court. It's very nice to say this is what will happen in a handbook because you think you're being informational, but it can't have contractual efficacy. And if it does have contractual efficacy, then it can contradict what you've actually done specifically in the agreement. So to me, talking about termination and what will specifically happen on termination has no place in an employee handbook. An employee handbook should not be viewed really as a contractual document. And if you do want it to be that way, you have to look at the clauses in it and make sure that they would pass muster, because you're taking that handbook and importing it wholesale into the agreement with all of its warts.
And then there's a question here about what happens if you have existing employees, and this person who's asking, I know, has about sort of 100 or so employees, many of whom are all family and they know each other from the community and they've all been there for 35 years. And they're all on contracts, and although we've done our work to prepare some agreements that are new and fancy and have the agreements up to snuff, they have a lot of folks that they might be hesitant to impose these new agreements. So what happens when an employee says no?
Well, I mean, you have to keep in mind, A, you may never terminate the employee, right? I mean, they've been there for 35 years. They could be there for 45 years. B, and forgive me for being blunt about this, but, they may just die while they're still employed by you. In other words, there's no mandatory retirement. And there are different ways that employment can end. So employment can end through termination, which is your action. It can end through death or disability, which is external. It can end because of resignation. So there are a lot of different ways that employment can come to an end. And in addition to that, if the company decides, for example, to shut down a division, a particular line of work, something along those lines, there's always the option of working notice. And I have been able successfully in some cases to give working notice to long service employees to say, you will be done a year from now or 2 years from now. And the employee, contrary to popular belief, doesn't always immediately go and sabotage the computer system. Sometimes they just work out their notice and leave. So there's, I would not panic if I can't fix the agreement, because it may never happen. These are all contingencies, and because there are other ways out. And in the end, if you have to terminate somebody and you have to package them out significantly, I mean, it's a cost of doing business, unfortunately. But, you know, an employee has no obligation to sign an agreement because you present them with one. And if I were dealing with 35-year employees, I mean, I'm having a lot of these cases these days of people who want to retire, but they want severance packages too. And I've had a number of situations, it's quite funny, really, where people feel that they've kind of earned this severance package. And, you know, you have to disabuse them and say, well, no, if you're leaving voluntarily, you don't get one. And then it becomes a battle of wills as to who wants the employment to end first. So it's a very tricky situation, but I don't think the mere fact that a severance package is in the offing potentially, if the termination ever has to happen, is enough for us to, you know, say, well, now we have to suddenly do something about this. We don't. If it's not appropriate to approach the employee, then don't.
All right, well, Allison, thank you very much. And I think you
My pleasure.
The most critical questions, but if the folks we haven't gotten to just ran out of time, I apologize for that. Please do feel free to send us an email and we'll do our best to respond. There are still some good questions in the queue. Maybe we'll find some time later in the day.
I'd be happy to answer any of those questions by email. No problem.
There, she's volunteered. Okay,
absolutely.
The neatest thing to do. Yeah, as you can see, she's sitting comfortably at home today, and much easier to type than to talk. So thanks
absolutely,
very much, Allison, and
my pleasure.
Soon.
Thanks. Enjoy your day, folks.
All right, so folks, now I'm pleased to introduce my friend and partner Ryan Conlon, who's going to speak about recent changes in health and safety law here in Ontario, and I'll leave it to him to blow your hair off because yeah, it's some good times are coming.
Well, it's setting the standard at blowing one's hair off in occupational health and safety. That's a new one, that's for sure. Good morning, everyone. As Jeremy indicated, my name is Ryan Conlon. I am a partner at Stringers, and a significant part of my practice is in the area of occupational health and safety. This is one of two presentations you're going to hear today that is focused on some legislative change that comes out of the interestingly named Working for Workers Act. I don't know what it is about conservative governments in Ontario having these political names for legislation, but I'm going to focus on the aspects of this legislation that deal with occupational health and safety. And it's a cornucopia of topics, everything from substantive changes to fines and sentencing factors to delivery drivers and bathrooms. We're going to go all over the place on health and safety today. Most significantly, like when we think of prosecutions in the occupational health and safety context, we're mostly thinking usually about companies, right? If you pay a trip to the Ministry of Labor, Skills, Development, Training, and Immigration, or whatever it calls itself this week, you'll see a long list of companies that have been fined. But the reality is, it has become increasingly common for fines to be individuals being charged in occupational health and safety cases. Anecdotally, I mean, I don't have actual statistics on this, but there is in my own practice, I've seen a significant increase in the number of individuals that are being charged. And so this legislation raises the maximum fine that could be imposed against individuals from $100,000 to $500,000 per count. This is what this used to be the maximum fine up until relatively recently against employers, the corporations. 3 years ago, that's as much as a corporation could be fined. And now that's the maximum fine for individuals. With one exception. Individuals would be folks like supervisors and workers primarily, but for officers and directors, which is interestingly enough is a term not defined by the legislation, but generally speaking has been referred to basically C-suite type executive level positions. The maximum fine has increased to $1.5 million per count, which is a 15-fold increase and is the same fine, which can be imposed against corporations. So that's a very significant change. I mean, one thing I should point out is how common do you think prosecutions are against officers and directors? Not common. There has been very few of them. And most of those prosecutions have been in the criminal context under the criminal code, where liability of the corporation is very much focused on the actions of a senior officer. So this increase to the fines, in my view, should put senior executives on notice that the government is signaling that fines should increase dramatically. And one should surmise from that, I assume, that there's a direction being given to Ministry of Labor prosecutors, who are the ones that decide what charges should be laid, to start focusing on officers and directors. So what does that mean for you? I think what it means is, I think it's a good opportunity to review C-suite due diligence, to make sure that occupational health and safety is on the agenda at board level meetings. That look, I mean, the topic of officer and director due diligence is probably a 45-minute discussion for another day. But the basics of it are things like having occupational health and safety orders, joint health and safety committee recommendations, major safety statistics on high risk near misses, all those kind of things that need to be documented at a board level, because having nothing at the board level addressing health and safety puts a officer and director in a difficult position. We don't have a lot of case law on what due diligence means for officers and directors. Leading case on the subject is still Regina versus Ted Bata Shoes, which was a very old environmental case from the 1990s. But what it did say is a director was acquitted by having written directives issued to lower levels of management to deal with environmental noncompliance that had been brought to his attention. So, I mean, the due diligence is exercised differently by officers and directors than it would be by frontline staff. So, but in the end, it's something I think that's has been slipped upon on the last 20 years, because the truth is there just hasn't been a lot of prosecutions in the regulatory context, and even in the criminal context. That's a relatively small number of them. And so what does this mean for fines generally against supervisors? Does that mean if you're, a first offender that, you would have been fined 25,000 perhaps for a fatality, or 20, would you now be fined 100 or 150? There's a legal debate going on about this. Some courts have signaled that an increase in the maximum fine should result in an increase in the range of penalties imposed, without, getting down to a mechanical calculation of what that increase should look like. And others have said, look, if the government wanted to increase the fine for first offenders, the way to do that is to impose a minimum fine, which isn't present in the Ontario legislation. So there's a debate. The cases I'm referring to are all from outside Ontario. Carrier's from Saskatchewan, Hoyok's from Nova Scotia, and Gibson is from Alberta. So, I mean, look, bottom line, if you want my take on it, certainly what prosecutors are saying, they're saying that the increased fines should result in much higher penalties as far as individuals are concerned. I can say in the early days of doing some plea bargaining involving individuals, I haven't noticed courts heading in that direction. We'll just have to see. One other piece of this I'm often asked: is there a prohibition against indemnifying an individual for a fine? Like, in other words, if one of your supervisors or officers is fined, can the company pick up the tab? The answer to that question may surprise you. The answer is yes. The company can pay a fine. In fact, it would be prudent for officers and directors to have indemnification language in their own individual contracts, if I was advising an officer. The prosecutors don't like this reality, but as long as no one is misleading the court, like going in to say that the fine should be lower because, the poor defendant is impecunious when in fact the company's paying the bill, that would be misleading the court. That would be arguably perpetuating a fraud on the court. But as long as no chicanery along those lines are happening, there's no prohibition in Ontario law or anywhere else in Canada I'm aware of for a company not to pay the fine. And in fact, it happens with a surprising degree of regularity. Sometimes there are situations where one defendant pays the other defendant's fine if someone wants to plead guilty. It happens. It's just not something that's talked about extensively. Another big change in Ontario, most of you who've had some familiarity would know that Ontario has historically had a 1-year limitation period from when the offense comes to the attention of the inspector to lay charges. And and I'm not obviously asking if anyone's ever been charged, but if you have, you probably know that you get the summons on like day 363 of the 365. They're not historically have moved with alacrity to lay health and safety charges. That increases now to 2 years. Certainly Ministry of Labor prosecutors have pointed out that there's other regulatory legislation where the limitation period is 2 years, and that is true. But it's an unfortunate development from an employer's perspective because, look, we all know that it's difficult enough to defend a health and safety case. If you get a prosecution 2 years after something happens, that means that you're most likely going to trial if you're defending it around 3 years after the event has taken place. And I can tell you, having tried some cases like that, where in the past where the courts were, shall we say, less than concerned about constitutional delay, and that's changed for corporations in recent years. But it's a very challenging thing to do because people move on, people's memories fade, and the documents needed for a due diligence defense become more difficult to access. So this, from my perspective, not surprisingly, sitting as a defense lawyer, is a very unfortunate event. The question remains, is the Ministry of Labor going to wait till the last minute to lay charges in 2 years, or will they be moving a little more quickly? This legislation's just been enacted, so the answer is I don't know. I suspect that they will be taking their time. Like there's nothing, basically they have a tickler system like any other lawyers do when the limitation period expires, and the cases where the limitation period's expiring get the most attention. Otherwise, they lose their right to prosecute. One of the other things I think that becomes challenging with this 2 years is in the early stages of an investigation, the Occupational Health and Safety Act gives Ministry of Labor inspectors unbelievable powers. You'd be surprised at the level of powers they have. They're more than the police. They can enter your workplace at any time without notice or warrant. They can speak to anyone they want and make inquiries in the workplace. They can seize documents, all kinds of things the police can't do without a warrant. But ultimately, the courts have said that once they have come to have reasonable and probable grounds that an offense has been committed, they're supposed to be like the police and go get a search warrant if they're going to show up and caution individuals who they are considering charging, and all those kind of things. But if this limitation period is going to be increasing for 2 years, giving them much longer to investigate, it raises the question as to whether or not the courts are going to start insisting they get warrants as time goes on. We'll see where that lands, but certainly it suggests to me if the Ministry of Labor is showing up a year and a half after an accident, still relying on regulatory inspection powers, that's a problematic red flag to me that they ought to be getting a warrant, and you ought to be getting legal advice, at least raising that issue with them, so there's no question that you didn't consent to the search, right? That's what they always want to say when they're in legal hot water when they should have got a warrant. The other question that is, what about pre-charge delay? There's certainly been a number of cases, including one I'm going to argue at Old City Hall next month, I'm sorry, that is on a question of pre-charge delay, where basically that our argument is that the cause of the accident in this instance was fairly obvious, and the Ministry of Labor waited until the last possible second to lay charges, and a number of COVID-related events dragged the case just up to the end of the constitutional limit of 18 months for a trial to be brought. And we're going to say, look, our point is, look, you should have moved this thing on with alacrity. We have some prejudice that's going there. We'll see where that particular case goes. Pre-charge delay is a tough argument to make, but it does seem to me that will the courts now, with a 2-year limitation period, say to the ministry, look, in straightforward cases, let's face it, all the Crown is required to prove in many cases that is just the accident happened, right? Like, just to use an all too unfortunate example, someone falls off a building. What does the Crown have to prove? The fall protection. Well, someone fell off. They weren't wearing fall protection. That imports the offense. What else do you need? You can put on your case in, a rather straightforward manner. Well, we'll see. We'll see where the pre-charge delay issue goes. Next issue I wanted to look at is, what are the factors a court has to consider on sentencing? And this was historically come out of a well-known Court of Appeals decision called Cottonfelds, which has been cited across the country in all kinds of regulatory cases of one kind or another. But I think that what's happened in this legislation is the government has now spelled out what it is the court has to consider. And from an occupational health and safety perspective, this is a very important amendment because much like with wrongful dismissal cases, a relatively small percentage of these go to trial. Most of them are resolved by means of a plea bargain in most cases. And that is largely because of oftentimes they're very difficult to defend. They're expensive to defend. So oftentimes companies are looking at resolving them. So historically, the amount of the fine was determined by of course, the court would never say it's simple, by a complex considerations, including the size of the company involved, scope of economic activity, the potential harm, and the maximum penalty. And above all, the fine will need to be determined by deterrence. In other words, to deter both the specific accused and the broader community generally from committing the offense. The government came out of nowhere. Like, there wasn't like some great demand, from what I understand, in the legal community on either side to implement these these factors. But it just sort of it just sort of goes through just to go through them, that as to what they are. Some of them are in cotton felts and some of them aren't. I mean, obviously, they have to consider whether or not the offense resulted in the death or serious injury. This is nothing new. It's always been an aggravating factor on sentence if someone who got hurt or died. I don't think that's a controversial proposition. The defendant committed the offense recklessly. And this is where we're starting to blur the lines, aren't we, a little bit, between regulatory legislation and criminal. Like occupational health and safety law is a strict liability offense. If they can prove the offense happened beyond a reasonable doubt, you're guilty, unless you yourself can prove yourself innocent on a standard of due diligence. Either you took all reasonable precautions or you had an honest belief in a mistaken set of facts. But once we start getting into recklessness, that sort of starts blurring the lines between regulatory offenses and things that are more commonly regarded as criminal. It may very well be that there is the ability of a prosecutor to call evidence at a sentencing hearing. And I think they may have to, in certain cases, to establish recklessness. Defendant disregarded the order of an inspector. Well, that's not complicated. If you disregarded an order, that's going to be an aggravating factor and is frankly potentially a charge in its own right. You have a prior record. Well, okay. I don't think anyone that's always has been a factor in sentencing in any place, anywhere, in any criminal, quasi-criminal scheme anywhere in the world, I would think. But here's where things get a little tricky. The defendant has a record of non-compliance with this act or regulations. That doesn't mean a prior offense. That's not a record. That means that they can, what they're going to do is introduce things like field visit reports and orders that have been issued to employers as an evidence of non-compliance, remembering that an order has to be grounded in non-compliance with the legislation. This means if you're getting orders, you got to take those things seriously. I mean, for more than, there are times the employer just says, I don't want to appeal this because look, it doesn't really matter to me. You want to make sure that if there's questionable orders, you appeal them, because these orders can then be introduced as an aggravating factor on sentence. Number 6, is the defendant lacks remorse. I take significant issue with this provision. In my view, it's unconstitutional. It has always been that if a defendant shows remorse and to satisfy the court they were remorseful for what they did, that is a mitigating factor on sentence. But if a defendant who lacks remorse, in my view, is coming awfully close, and the Court of Appeal itself has said this, to interfering with an individual's right to full answer in defense to a charge. Lacking remorse is something that even in criminal cases, where there's like a requirement to most of the time prove intent, courts have commented that that's a problem. So we'll see where it goes. If a prosecutor were to try to rely on a situation like this, it's my view that this would be challenged for a lack of constitutionality. There's an element of moral blameworthiness to the defendant's conduct. Again, moving into this, away from the sort of regulatory strict liability into these criminal law concepts, which sure, this moral blameworthiness has been a factor in criminal cases. In a regulatory case, again, I think it's unfortunate to introduce this element to it. In committing the offense, the defendant was motivated by a desire to increase revenue or to decrease costs. Okay, gotcha. That's always been a factor, that if you were basically cutting corners to save money, that's going to point to a higher fine. That's not complicated. That usually starts getting into criminal territory if you can actually prove that. Believe it or not, those kind of cases are relatively rare. You could actually prove that, but they are out there. After the commission of the offense, the defendant attempted to conceal the commission of the offense from the ministry or other public authorities, or B, failed to cooperate with the ministry. You can see that my legal antenna is alive to this one for a couple of reasons. Look, there are certain instances where you are required to report things to the Ministry of Labor. We all remember Blue Mountain and the fight about for critical injuries, fatalities, explosions, certain other things that are in the act, you're required to report to the ministry. There are other circumstances like commencing a construction project or a window cleaning job. There are certain notifications required. But the bottom line is that when you're talking about concealing information, how does that sort of, are you supposed to hand the ministry their case on a silver platter? You're supposed to give all of the evidence in your possession? So failing to cooperate, I think I take issue with it. There is circumstances where you can be charged with obstruction of an inspector. Certainly that would be like lying to inspector, misleading an inspector, acting in an overt way to alter or tamper with evidence. I had a recent case where one of the co-defendants submitted a fake traffic protection plan to the Ministry of Labor after a serious accident on a construction project. Okay. That's an aggravating factor, not only on sentence, though, that's obstruction of justice, criminal obstruction of justice. So I think these provisions, it's very difficult to draw the line between those kind of circumstances, like forgery, the example I just gave, versus someone who's just exercising their constitutional right that doesn't wish to, wishes to exercise their right to fully answer in defense and against self-incrimination. So that is the new, so those are the new sentencing factors. This is something, the next thing I want to get to is something that's just sort of come out of nowhere. Anyone hear a lot of debates about whether we should have an naloxone kit in the workplace? All right. So in some workplaces, this would be a real reality that in certain situations that this was something you're probably already dealing with. For others, it's probably something that's coming out of out of left field. These provisions haven't been proclaimed yet, but the law now is going to require that where an employer becomes aware of or ought reasonably to be aware that there may be a risk of having a worker having an opioid overdose at a workplace, the employer is required to have a naloxone kit present at the workplace. And there is detailed provisions relating to training of the workers and storage of these kits and things along those lines. There has been a lot of discussion in the province of Ontario about how an employer is really supposed to assess this risk. Because let's face it, there are some limitations, right? Ontario law places strict limits on the right of employers to seek medical information from employees, right? Ontario law also, as we well know, places strict limits on the right to conduct drug testing in most circumstances, unlike in the US, where that's pretty much a carte blanche. So the type of common sense things that, if we were sitting 90 miles down the road in Buffalo, that would, you could probably do to respond to this, aren't out there. I honestly think that, to be honest, I was on a panel with a Ministry of Labor prosecutor talking about this, and I'm not even really sure they know themselves, really. I don't think this was something that came from within the ministry. So from within like a big push from the sort of bureaucratic side of government. So, I think that what you react is common sense. Like if you are in an industry where these type of situations appear to be more common than in others. If you're dealing with a vulnerable population, for example, that would be an example of where you could have one. Some of my clients simply say, well, what's the downside to having one? Really, at the end of the day, comply and train. Well, as long as you're going to comply, I guess there isn't. But really, I think, and I'm not going to expect that you're going to see a whole lot of prosecutions for stuff like this, except in flagrant circumstances where it's required. But I think one of the ways, and perhaps the key way this can be dealt with, is I think that you need to raise it with your Joint Health and Safety Committee or your Health and Safety representative. The committee itself can speak to this issue. It's an exercise in due diligence that if some inspector shows up and asks, where's the naloxone kit, you can at least say we conducted a risk assessment, and a key part of that risk assessment was with the Joint Health and Safety Committee. No recommendation came forward from the committee for one. This was our conclusion, and that is that. Once this law is proclaimed, you just want to do something about it. And it may very well be, some of you may already have these kits because for reasons that are just common sense and obvious, that you might have many other safety devices in the workplace. My last point on this, and it's going to editorialize a little bit, is the Occupational Health and Safety Act has historically been silent on narcotics and alcohol abuse in the workplace. It is the one giant red big elephant in the room that no one in health and safety law ever wants to deal with. They just don't. It's arguably dealt with under the General Duty Clause, but there's no provincial level health and safety legislation in Canada that addresses this issue outside the criminal code, which is obviously not workplace safety legislation. So maybe this is the first sign that perhaps at some point the government of Ontario will and others will finally take this issue seriously and then perhaps impose not only some obligations, but gives employers some rights in these circumstances to address it. These kits will be life-saving for those who are subject to them. But it's a small step to what I think is a much more important, broader discussion about the consequences of people being intoxicated or impaired by drugs and alcohol at work. And I'm going to close my remarks on topics dealing with washrooms. I haven't talked about it as I've ever said that on one of these before. But this again has been something that's not got a lot of attention. So again, I think another issue for the Joint Health and Safety Committee to look at. It's a duty of owners, and an owner is broadly defined under health and safety legislation. If you can basically control the workplace, whether you're a lessee, you don't have to own the property, like in the sort of common law, I'm the owner of my house situation. If you basically control a premises, you're the owner of the workplace, whether or not you technically are renting the premises from someone else. And basically, you have to ensure that access to a washroom is provided on request. This is the actual wording of the legislation. I haven't paraphrased it here. On request to a worker who is present at the workplace to deliver anything to the workplace or to collect anything from the workplace for delivery elsewhere. So basically, they're saying you have to let someone who's a delivery person, courier driver, or I don't know, someone dropping off someone's lunch, I don't know, to use the washroom. There are exceptions if providing access would not be reasonable or practical for reasons relating to the health or safety of any person at the workplace, including the worker who requests to use a washroom. Notice they use the word worker, so it has to be someone working for somebody. So what does not reasonable or practical mean? I mean, I think it's obvious if you're walking through the dangerous factory floor. If providing access would not be reasonable or practical having regard to the circumstances, not limited to the nature of the workplace, the type of work at the workplace, the conditions of the workplace, the security of any person at the workplace. And in those circumstances, again, it's similar to A, somewhat ambiguous, but sir, if you're in provincial jail, I guess you don't have to let the FedEx driver into the area where the inmates are being incarcerated to use the washroom, or again, it's if the floor is slippery or if there's hazards. So I mean, again, I think you want to assess this particular issue, because I understand certainly that certain trade unions that are representing delivery drivers have pushed for this legislation, and they be quite happy to phone the Ministry of Labor and complain. And it's not, so you might face that. And lastly, the exception is if the washroom can only be accessed to a private dwelling. So if your workplace is actually your own home, you don't have to let the FedEx driver to use the washrooms. So, I mean, obviously, as I pointed out, owners broadly defined. I mean, again, I encourage you to get input from what is reasonable or practical, and be wary of human rights issues arising out of this. You don't want to have a lot of discretion. You want some kind of policy in writing to deal with these issues, so you don't have someone saying that you are denying the driver or the worker access on an enumerated ground under the Human Rights Code. Whatever that enumerated ground may be. So that's something to consider. So really the homework from this presentation for Joint Health and Safety Committee stuff is naloxone and washroom access and C-suite due diligence are sort of the big points I wanted to take. So lastly, before we get to Q&A, I'm sure there'll be some questions arising from this. Good chances that there's that prosecutors will seek higher penalties against individuals. I mean, I think you should remind, even if you're doing safety presentations for your own workers, I think you need to remind those workers they themselves can be prosecuted. There is an increasing trend. The Ministry of Labor has historically been criticized for not prosecuting workers who violate health and safety law. To their credit or discredit, depending on your point of view, they're prosecuting more people. Workers who do something negligent, even unionized frontline workers who do something negligent face potentially serious penalties, and the costs of defending these cases are high. Prosecutions and directors against officers and directors may become more common. I don't know. Certainly the legislation is suggesting that they should pay more attention to that. So that's important for the company owner, C-suite type folks. It's important to challenge questionable orders from inspectors. Again, now that they have this ability to rely on this sort of amorphous regulatory history, you want to do it. And lastly, it may take longer for charges to be laid and brought to trial. It looks like they have 2 years to bring them, so you might be, it might be the next Olympics by the time you're dealing with a trial. Lastly, now that there's this bizarre, arguably unconstitutional cooperation provisions as a sentencing factor, you really want to get some legal advice as to what in certain circumstances, as to what your obligations are or are not. In those circumstances. My view, your right to cooperate, your obligation to cooperate is confined to what the statute requires, which is, which is where the Ministry of Labor has where the Ministry of Labor is investigating that they have inspection powers that you comply with their orders, comply with their requests. And if you have a question or believe they have reasonable and probable grounds, respectfully raise those kind of issues. But like, this is a really kind of complicated stuff that if you're in that situation, you want to get some advice on in the moment. So that's the health and safety roundup for this year. I'll turn it back over to Jeremy.
All right. So, Ryan, we do have a few questions that have come in, but if everyone has burning questions, we've got about 15 minutes to go through whatever we can. So one question we have here is, can health and safety inspectors enter and audit a federally regulated business that is situated in Ontario, or I guess any province? And if not, well, why don't I just say, the answer is yes, first of all, so why don't I just leave that? And you could tell us who and how. How about that?
Sorry, Jeremy, can you repeat that question, please?
Can health and safety inspectors, in this case, Ontario health and safety inspectors, can they exercise their powers to enter a federally regulated business?
That becomes actually, I think that question is actually a little more complicated, Jeremy. I mean, arguably they can't actually. But I mean, it seems, it gets a bit tricky. It's an incredibly tricky question though, when you have federally regulated business in sort of the same place as a provincially regulated business. And let me just give you an obvious example. If you have like a Service Canada office in a mall, certainly the provincial authorities can walk into the mall. Can they walk into the Service Canada and start office and start auditing it? I think there's a good argument they can't. But then it gets sort of tricky. What about an airport where you have a whole bunch of different people that are federally regulated, like construction workers, like certain baggage handlers are federal, but the guy who's cleaning the airport is provincial. I mean, it's a great question for a law school exam, and reminds me of some cases I've done. But the answer is, whoever is asking this question, just reach out to me specifically. I need to know the context to give you a more definitive answer. And lastly, I'm not sure why the Ministry of Labor would want to do that, but picking a fight with the Ministry of Labor over that particular point, if they don't have jurisdiction, might be a complicated issue.
Yes. In fairness to me, when I first read that question, I just thought it said health and safety inspector, not Ontario health and safety inspector. But yes, it was a hidden question within an egg there. All right. So Ryan, another question here. What about having CORE or ISO certification as a form of due diligence? Have you seen any prosecutions that sort of you thought would have happened but don't, because an employer is taking the time to go through those very administrative and cost intensive processes?
Yes, I have, specifically in reference to ISO. Let's just sort of bring this back for those of you who are not like sort of buried in health and safety. ISO is the international standards organization that has an occupational health and safety standard, right? And you can pay a significant sum of money to be audited to comply with that international standard. It's not just used in Canada; it's used all over the world. CORE is more of a made in Canada concept. Primarily, it originally started out west. And has come to Ontario. It's particularly common in the construction industry. It doesn't have the international rigor of ISO, but certainly having a health and safety management system, whether it's CORE or ISO or some of the other ones that are out there, if you're actually doing it and following up and doing what those systems say, that certainly will improve your chances of establishing due diligence, either in court or to satisfy the inspector that shouldn't be charged. And I encourage people to pursue those issues. And
we've got a question here about washroom access.
I'm not surprised by that. It's a very scintillating part of the presentation.
Does washroom access have to be part of an actual policy, or is it sufficient to have a practice of allowing these folks to come into the washroom and use it?
This is not one of those. There are certain times where the Occupational Health and Safety Act prescribes that thou shalt have a policy on certain things. Harassment, for example. There is not such a policy requirement for washrooms. My view is that it's a best practice to have a policy because it avoids, this is not so much a health and safety comment, but it avoids the risk of someone saying that some particular employee exercised their discretion in a capricious and arbitrary manner to deny someone access, and they say, well, that was because of a characteristic that is protected under the Human Rights Code.
So far, those are the only questions we have that have been submitted. One question that I had as you were going through the new sentencing factors was, if you've got an accident where someone's been hurt or it's a near miss and it's fairly substantial, especially one that had to be reported with a notice to the health and safety branch of the Ministry of Labor, would you take any different steps than you normally would as a result of this long lead time of the 2-year limitation now being in effect?
When I take any additional steps, I guess I would. I think one of the things I think that becomes important is that, these were all good best practices before, but I think they become increasingly important. One of them is you want to get statements, and you want to get those statements in writing, and you want to get them signed. Ideally, you probably want to record them and have them transcribed, because this allows, if you have a trial way down the road, to refresh someone's memory. You can impeach someone's evidence by saying, well, we're going to play the tape of what you told me on, November the 2nd, 2022, with respect to what you were told about fall protection policies. And was that, which answer is better? The one you said 2 years ago, or the one you're saying now when you don't work for my client anymore and you're on trial and you're, so that's one of the, one of the practices I think that's most important. It's the things that's in the immediate aftermath of the accident. The other thing is to keep track of what versions of policies and training records that were in place at the time. You can't, if you're going to introduce a policy in court, it can't be one that applies after the date of the accident. It has to be the one that applies on the date in question. So version control becomes helpful. And I guess lastly, it's if we're anticipating that we need to get an expert out there, let's if we can get the expert before we're charged with something, if we can sort of find out where we're at and do it while it's fresh. Lastly, preservation of evidence. Let's just say that the accident was about the condition of a particular piece of equipment. You would want to make sure that we can isolate that piece of equipment and say nothing's been done to it, because we may want to have testing done on that equipment. We may not know what the ministry's charge is going to be, but we're going to have to establish where that equipment was kept and what state it's in. These are all technicalities that the longer it takes to get to court, the more likely there's going to be gaps. And these are things that always should have been done in the immediate aftermath of an accident, but they become more important now.
A question came in about these naloxone kits, and does the new law, once it comes into force, require you to conduct this risk assessment? Or if you're going to just sort of, as you suggested, buy them and have them on site and give the training regardless whether there's this risk that you're aware of, is that enough? Do you actually have to go through that risk assessment?
I don't think you need to go through the risk assessment process if you conclude you're going to have the kits and comply with the law. If that's what you're going to do, then no. I think the risk assessment at that point is just paperwork. You at that point you've determined there's a risk, or at least are prepared to decided not to take the risk of a court coming to a different conclusion. And so I don't think a risk assessment is necessary in that context.
So those are all the questions that we've got in here. I'm just looking around to see if there's any additionals that have come in. No, I'm not seeing anyone feverishly writing here. Oh, we do have someone who, did you write it down? All right, sorry. We normally have someone coming to collect these things. All right. Thanks, Lana. All right, you'll have to answer on the fly. It better be a good question. Let's see. Now that we've
Naloxone kit, remote work environments. This is what I love about it. Feels like I'm going back to law school. It's really fun. All right, naloxone kit, remote work environments. If we have knowledge of an opioid issue with a staff member, would we be required to send those kits out to the employee's home? That is a great question, right? Because it relates to what the definition of workplace is or isn't. I think that would be a rather gross stretch of what the law provides. There's nothing stopping you from doing it, but I don't think under the phrasing of the law, chances are better than not that it's going to be interpreted that way. That's a bit, that would be a bit, but I've been surprised before at how far the Ministry of Labor wants to stretch the law. You'll hear about my fun at the Supreme Court this afternoon. So, and it suffices, but on a serious note, no, I don't think it would extend that far.
Now, of course, you have spoken at other conferences, Ryan, about WSIB and the no-fault system and that sort of thing. And so if an employee were to have an overdose and suffer from some issues in their remote workplace, that would be a compensable injury, wouldn't it?
Well, not necessarily, Jeremy. I mean, I think the answer to that is that because a workplace accident occurs, now we're getting WCB, why not?
We have a few minutes. I'm
okay.
making up questions.
All right, so it goes, a compensable accident occurs in and of the course of employment. It's sort of like if someone has a heart attack at work, it's not necessarily compensable. It has to be the work that causes the heart attack. Arguably, if you're using drugs, that takes you outside the course of your employment, and therefore the claim would likely be denied. That being said, I mean, I'm in the middle of a case right now where the issue is if someone was driving drunk, well, on company time, and has come to the conclusion that they should be allowed to collect workers' comp benefits for their criminal behavior. Their claim has been denied, but they are appealing it. So it's similar to that. I mean, the answer is, I think at the board level, at least, that claim would be denied, but I can't say it isn't possible that someone could say that, well, you're in the course of your employment while you're doing drugs. Who knows?
So going back to these naloxone kits, it seems to be a hot topic. And I think you talked about the sort of discussion in the bar and in the employer community about how employers are supposed to know. So we have a question that's come in, if you suspect vulnerable workers in the area and you have these kits, is it enough to have these things in place, or do you now have to implement things like providing access to rehab and other reasonable precautions and things of that nature?
This legislation speaks specifically to having naloxone kits. It doesn't impose any specific obligations beyond that. As I've said, the general duty clause under the Act, which is for the employer, section 25 sub 2H, that says thou shalt take all precautions reasonable in the circumstances for the protection of a worker, it means essentially anything the Ministry of Labour wants it to mean in a way. But the bottom line reality is that the Ontario government and the Ministry of Labour has operated, in my view, as if drug and alcohol issues don't arise under that section. It would be a dramatic interpretation to change in the law. To start looking at these things through a health and safety lens. How they're often looked at is in the context of under a collective agreement or under the Human Rights Code in terms of accommodation. But it's something under the health and safety lens. These provisions don't explicitly change anything around that. They just require you to have a kit.
Okay. So with that, I think that we'll take a slightly longer break. So that will take us to 10:50 this morning. So if you could all, go and be about your business and have some coffees and refresh and hit that washroom, especially if you get in. And if you could join us again at 10:50. Thanks very much, Ryan.
Welcome back. I assume you didn't quit on us, so you're still here, fully engaged in our program today. So I'm going to be talking about quiet quitting, which of course you've all heard about it. It's been a big deal in the news and in HR publications, and it might even be something that you have had to deal with or encounter in your workplace. So as a good lawyer, I always like to start with like definitions and what we're talking about. So what do we mean by quiet quitting? Well, I read some articles on it and did some research on the internet, because that's where we do research these days, and to figure out, what exactly are we talking about out there? And it seems the consensus among HR professionals is we're talking about employees not engaged in work, or they're just doing the bare minimum. So there's a fair continuum there. So it could be somebody who just is at home working remotely, surfing the internet, or like dealing with their dog or kids, or just out doing something else all day and not really working at all. Or it could be somebody who's working, showing up, but not really engaged, not really productive. And I think we've all seen some examples of it. It might be, spending a lot of time on their phone, surfing the internet during working hours. It could be during meetings. They're continually distracted. They appear to be on the meeting, but for all you know, they're like watching TikTok videos during the meeting. Could be remote workers who have a lot of personal matters or appointments during their workday, and so they're in and out, and which chops up the workday, right? Because if you're running off to the doctor appointment or dentist, or you got to pick up your kid for an hour, well, that takes you out of your workflow, and it takes a while to get back into your workflow. And sometimes, of course, we might see it where we get delayed response to communications, and it's not clear whether they're really picking up or reading it. They might tell you, oh, well, I was swamped, so I couldn't get back to you, but who knows? But that might be a symptom of quiet quitting. Could also be a symptom of somebody who's overworked, but could be either. Now, is this so-called epidemic of quiet quitting a real thing? Well, I think it is, based on conversations I've had with clients, some of you might actually be with us today. So I think from personal experience, it's out there, it's real. But I found an interesting article where Gallup had done a survey on it. And they found on their survey of employees that quiet quitters on their methodology make up a shocking at least 40% of the US workforce, or 50%. So we're talking about like maybe half of the employees fall into that category of not doing much at all or not engaged. And engaged workers are only 32%. So a third. And actively engaged, like really like, nose to the grindstone, fully into it, only account for 18% of the workforce. Interestingly, they noted that there seemed to be a drop in engagement starting in the second half of 2021. Now, why might that be? Well, we could maybe look to a few factors. I think obviously the pandemic would be one. By the middle of 2021, remember, we're like a year into this thing, and a lot of people are working remotely, or disruption in the usual workflow. That could be part of it. As well, at the same time, as I'm sure everyone with us today is aware, like we started to see a real serious labor shortage develop in 2021. So maybe there's creeped into employees' mentality that, well, if I don't like this job, or if you fire me, well, I can go get a job somewhere else like real quickly and not have to worry about it. So maybe that's part of it. As well, there seems to be, according to the Gallup survey, a higher rate of quiet quitting or lower engagement among younger workers. Now, in the same survey, they looked at what some of the causes of quiet quitting appear to be. And this slide just sets out some of them, like a lack of clarity about expectations, lack of opportunities to learn and grow, not feeling cared about, missing a connection to the employer's organization and its purpose and mission, and as well the remote hybrid work style we have now is also likely a contributing factor, which is interesting because there have been those surveys that have found that productivity did not go down with remote working. And just anecdotally talking to clients, that seemed to be the case. But I also seem to be getting some feedback from clients that over time, the productivity and engagement has dropped. So maybe for the first 6 months or year of the pandemic, there was a bit of a novelty factor for remote working, and people liked it at the beginning, but maybe now that's starting to wear off. Now, who knows what the answer is? Maybe a hybrid model is the answer. But of course, the challenge is if you tell people, well, you have to work in the office, not everybody wants to do that. And with the labor shortage, that just may not be something they're down with, and they might leave for another employer. And so rather than having a remote worker, you have no worker, and then you have an even bigger problem on your hands. Now, I'll be getting into the legal options that you can pursue as an employer. But before that, I think maybe just good to look at maybe the HR side of things, and most of you are HR professionals. So things you're probably well familiar with, but I think it's worth just reviewing before going legal, how you can try to increase that engagement. Some ways might be meetings. Now, you don't want to overdo the meetings, right? If you have too many meetings or meetings that people don't need to be on, that increases the chances of non-engagement, right? So I would say, rather than inviting people for meetings they don't really need to be on, maybe have focused meetings, maybe smaller groups on the meetings. That might increase engagement. Or you have meetings where it's more of a not necessarily on a particular work project, but almost a social aspect, or just to touch base with people to go over what your organization's goals and purposes are. Talk about the big picture stuff. As well, you could set goals for your employees. This seems to be an important thing for younger workers. They like to know what the objectives are and what your expectations are of them. Maybe for your employees who have been with you for years, they know what that is. But for your newer employees, think about setting goals and spending a bit of time with them on a regular basis to make clear what those are. And in doing all that, maybe you can try to build a sense of team, like maybe if you're working remotely, some social Google Hangout time, something like that. And if you do have people coming into your workplace, some kind of social interaction mixer of some sort to get that feeling of team back. Now, along with the kind of positive spin, well, there are more negative approaches to dealing with quiet quitting. And some of them that get into some legal issues, and they can include monitoring of performance improvement plans, often referred to as PIPs, warnings, and then ultimately termination of employment. So now I'm going to dig a bit deeper into some of the legal issues to be mindful of with each of those approaches. So with monitoring, the idea there is to basically keep an eye on what's going on, to see, are they working? Are they actually like logged in when they're supposed to be? Are there any keystrokes happening, right? Things like that. So there's, of course, these days you have electronic monitoring. And Jeff will be talking about the new requirement under the Employment Standards Act, that if you have any electronic monitoring and you have more than 25 employees, you need to have a policy that addresses it. So as you'll hear from him, you need to identify the purpose and the type of monitoring there. Now, the monitoring can take a variety of forms. Could be like just when the employee logs in and off during the day. Now, that might not tell you a whole lot, right? The employee could log in at 9 o'clock and log off at 5 o'clock, but spend the whole day on Instagram, right? So and has not replied to emails or completed the deliverables that you set out for them. But it's much more advanced than that these days. There's software there that can measure activity levels, like how many emails people are sending, keystrokes, if they're actually, doing what they're supposed to be doing. Can monitor, obviously, websites that people visit. So, obviously for some people, like it's appropriate that they're visiting certain websites. That might be part of the job. Maybe in your organization, you're fine with a little bit of mental break time. Okay, I'm going to go to Instagram for 10 minutes, no big deal. But, something you might want to keep an eye on, because if they're on Instagram for 2 hours, and their job is not like a social media platform manager for your organization, then that could be a big problem. So these are all options you have as an employer for monitoring. Now, the only thing you have to be careful of is not to intrude on people's privacy, right? Reasonable privacy expectations. And that's why I put here with emails, you can monitor their work email accounts. It's a good idea in your policy to let them know you're doing it. But for their work email account, you can monitor that. But let's say if you find an email from clearly their spouse, from their kid's school, from their doctor, you should not be reading those emails, right? So stay out of those emails. And as well, if you permit people to use, say, your company equipment to access personal email accounts, like maybe they have a personal Gmail account they might check once or twice a day. Again, you should not be monitoring what emails they have in their personal email accounts. So there's a line there which you shouldn't cross. And as some of you may be familiar with from past year's presentations, we now have what we refer to as a privacy tort. And what that means is the courts have said that, and they call it intrusion on seclusion. So basically, if you're spying on somebody unlawfully beyond where they have a reasonable expectation of privacy, then you can be sued for that. And just one last point on that, when you do have that policy that makes clear what you're monitoring, that helps insulate you from one of those lawsuits. Because they can't say, well, I had a reasonable expectation of privacy that, you wouldn't be checking my work email, for example, or monitoring what websites I might be visiting during my working hours. Then there's good old-fashioned non-electronic monitoring of performance, which is something employers have been doing since the beginning of employment relationships. You can still do it. It's fine. I actually think a lot of employers kind of forget that you can do this, right? Like, so in-person engagement, right? You can go up to your employees, hey, what's going on? What are you working on? Think you're going to get this done by 3 o'clock, right? In other words, like kind of over the shoulder kind of supervising. In an industrial setting, right, that could be the team lead or supervisor, keeping an eye on productivity on the assembly line, to use a traditional workplace example. Another way you can monitor what's happening in workplace is video surveillance. I put it under non-electronic because it's kind of old school technology with video, but if, for example, in a logistics center or warehouse, an employer's allowed to have video up. Now they should have signs saying this area is being surveyed publicly. And if you have a union, then there can sometimes be some issues to deal with in terms of video surveillance in a unionized workplace. But generally speaking, as long as you let people know that you're monitoring your workplace, that is fine. And if you find on your video surveillance that you've got groups of people hanging out doing nothing for significant periods of time during working time, then that's something you can address through discipline. And you don't have to just put up with it. And no employees don't have a right to privacy to hang out in the workplace doing nothing when they should actually be working. Now, as with most things, there's always a risk of overdoing it. And you don't want to end up in litigation or getting lawyers' letters or complaints over it. So, for example, if employees think you're like, micromanaging them, constantly looking over their shoulder, constantly asking them questions what they're doing, you could have somebody saying, look, you're creating a toxic workplace. Could allege that they're being subjected to harassment, might even result in a constructive dismissal claim. There are cases where employees claim that, the employer ratcheted up monitoring of their performance and everything they're doing so much that it amounted to constructive dismissal. So that can happen. So it's all about reasonableness. And again, if you overdo it, and you might have an employee bring a discrimination claim if they say, look, you're picking on me, monitoring me more than other employees because of some prohibited ground under the Human Rights Code, or even if it's not code related, they might claim that that's harassment and then file a harassment complaint. So again, it's all about reasonableness and not overdoing it. When it comes to performance improvement plans, they can be a valuable tool for dealing with your quiet quitters, as most of you are probably aware. But there are certain things you need to keep in mind for it to be effective legally. And we're going to be looking at some cases where employers kind of learn the hard way on how not to do it. First of all, in a good performance improvement plan will set clear objectives. Now, I know that's not always easy because you might have some employees, given the nature of their work, it's not like you can say you have to reach this target of 100 units sold every month, right? Like a sales employee. It might be more subjective than that. But the trick is to think how you can make it as clear and objective as possible so that down the road, if you do end up terminating for just cause, you can explain this and why you came up with these objectives. And also objectives that the employee can understand and hook on to in order to actually improve their performance. Then you need to give them a reasonable timeline, right? You can't expect miracles overnight. So a PIP's not going to work if you say, well, okay, I gave you the PIP last Friday and here it is Tuesday, and you did it again and now you're fired. That's not going to get you much if you end up in court. So set reasonable timeframes. I think one way to figure what that is might be the length of service of the employee. If you're dealing with a long service employee who's been a poor performer or quiet quitter for years, then you're going to need to give a bit of a longer runway for them to reach your objectives. Maybe 3 months, maybe 6 months, it all depends. And then ask if there's any reason why they're not meeting their performance objectives when you sit down to present the PIP. And the reason that's important is because afterwards you might find out, or they might allege that they have, say, a disability, maybe a mental health disability or cognitive impairment of some sort, or substance abuse addiction that was affecting their performance. So it's always good to say, look, is there any reason that we should know about that you're not reaching your objectives? And employers are sometimes afraid to ask the question because they think, well, if I find out that the person does have a mental health condition, if they're suffering from depression or has a substance abuse addiction, well, then I have to accommodate it. But what the courts and the human rights tribunals have made clear is that if there's any hint or indication that it's there, then you should be asking so that you can accommodate it. Then if you've asked the question and the employee says, no, there's nothing going on, then that will help you down the road. If the employee comes out and says, well, the reason I wasn't performing was because of my addiction or my mental health condition. Then when you are, another approach along with a PIP might be, or independent of a PIP, is written warning and progressive discipline, right? So when giving written warnings, you need to be clear as to why they're being disciplined, set expectations going forward, and advise that there might be further discipline and termination if they do not improve. And then finally, you have termination of employment. And this is, as Allison pointed out, is almost like capital punishment in the employment world. So just a couple tips here. Again, be mindful of potential human rights risks when terminating for poor performance. Is there like something going on in the background that might be the cause that you're going to end up getting a human rights complaint about? When terminating, be clear and upfront about the reason. If it's poor performance, make very clear to them that it's for poor performance. Don't try to sugarcoat it. Don't say, well, we're restructuring, right? Or we've just decided to go in a different direction. Because then if the employee comes back and does file a human rights complaint or says it's a reprisal for raising certain issues like how their overtime is paid, if you didn't give the reason, then quite frankly, a court or tribunal may not believe you later. So just cause for quiet quitting. Again, as Alison said, just cause is capital punishment. Means they don't get termination pay or notice of termination under the common law. Yes, there could be just cause for quiet quitting, but it can be hard to get there. It's a high bar, and it must effectively amount to repudiation of employment or fundamental breach. And generally speaking, there must be prior warnings. Now, I'm going to discuss a few cases that dealt with just cause for performance to give you an idea of how the courts look at these issues. The first one is Baker and Weyerhaeuser. This was a case from Alberta. The employee was a supervisor in a sawmill who had received a series of warnings for incidents of prior poor performance. Then there was a final incident where there was a small fire where the company found the employee didn't follow procedures. So then the company tried to rely on the prior discipline, saying that with the final incident amounted to just cause. The court disagreed, said it wasn't just cause. The court noted a couple things, that the discipline was not progressive. It was just a whole bunch of warnings, and there was no final warning. In other words, it was no like, okay, this is it. If there's any further incidents, you're going to be terminated for just cause. Now, a different outcome where just cause was found is in this case, Daniels and Canadian Gift and Table from 2003. Here, there were a number of incidents of insubordination by the employee. Apparently, she had a habit of going around the boss's back to go to the very top. The judge colorfully described her behavior as like a 12th century baron who ran her fiefdom as though like she had no allegiance whatsoever to the king and just did whatever she wanted. Now, the thing is here is she had been given clear written warnings about her behavior. And so the court noted there is this duty to warn before terminating for just cause, and she had been given a reasonable opportunity to improve. So considering the cumulative checkered past of the employee, the warnings, and the clear warning as to what would happen if it continued, the judge found just cause. So there's a win for employers. It can happen. Then another one going the other way, Buchanan and Word Communications from 1990. Here we had an employee, fairly long service, 10 years. The performance was apparently unsatisfactory for a long time. They were told verbally that their performance was lousy, and that's why they were only getting the bare minimum salary increases. And then finally, the employer had enough and terminated. And the judge there found that it amounted to basically condemnation. That, okay, fair enough, after enough years, the employer finally had enough. But clearly they didn't lay the groundwork with sufficiently clear warnings that, okay, this is it. This is the last time. It amounted to condemnation and no just cause. Now, one final note on just cause is here in Ontario, we have the Employment Standards Act, which in the wisdom of our legislature has a slightly different standard for terminating an employee than just cause. And that was the core of the issue in the Waxdale case. Because saying, you'll get no notice if it's just cause, well, that's under common law. And the Employment Standards Act has its own standard for when an employee doesn't receive notice of termination or severance pay. And that's when there's either willful misconduct or willful neglect of duty that is not trivial and has not been condoned by the employer. So the big difference there is the presence of the word willful, which the courts have found to be a higher standard than just cause under the common law. And an example of how this can work is this case from the Ontario Labour Relations Board, SACO and MMCC Solutions Canada. Here the employer, quite frankly, messed up. They had an employee, 7 years of reasonably good performance. Then they presented what they called the last chance agreement. Well, the employee didn't actually sign back on it, so it wasn't really an agreement, but a purported last chance. But in the hearing, apparently the employer couldn't explain the metrics they used for the last chance agreement, which obviously took away some of its force. Then the employer disciplined the employee again after that. So much for the last chance agreement. There's another incident. The employee gets a warning for that. And on top of it, the company apparently gave this employee a certificate of appreciation and asked him to work overtime shortly before he was dismissed. So considering all that, the board decided that this did not meet the standard of willful misconduct and that the performance was not willful. Granted, maybe there was poor performance, but it wasn't willful. So what that means is you could have an employee who's not entitled to anything under common law because of just cause, but they might be entitled to the minimum notice and termination or notice of termination and severance pay under the Employment Standards Act. So just to sum up some of the takeaways, if you're going down the just cause route, make sure you've given clear warnings, make clear the consequences of not improving. So that's first of all. Second, don't send mixed messages. So no positive employment reviews. I've seen those where an employee is a terrible performer, but the manager just checks off, meets expectations or something in the performance reviews. Don't give them discretionary bonuses either. And three, don't allow it to go on for years because you'll be found to have condoned it. And even if you have just cause, fourthly, they may still be entitled to statutory minimums under the Employment Standards Act. Okay, now I've saved a few minutes for Q&A time.
All right, so we do have a few that have come in. One of these questions relates to sort of the use of company equipment for personal use, emails and things like that. So if an employee does engage in permitted use, are we responsible for privacy and personal information that sort of flows through that in the same way that we would be for the purposes of an employee's file or payroll purposes and things like that? Are we now responsible for confidential information on our devices and systems that an employee chooses to use during their personal time?
So if the question is, if the employee uses their company equipment to access a personal email and there's confidential information on their personal email, do we have a duty for the confidentiality of that information? I would say no. But if, on the other hand, we don't have a right of access to it. And let's say if we found confidential information on their emails and published it, that would be a problem, right? You're exposing yourself to legal liability. But do we have a duty to ensure its security? No.
Regarding quiet quitting, so it sounds like this employer has generally permitted up to 50%, sort of on a flex time basis. It sounds like people can work remotely or work in the office. And then if they're dealing with someone who is underperforming, can they make that person attend 100% so they can have some more direct supervision? Or are there risks of them arguing they're being singled out with, for harassment or discrimination?
You can do that. Now, just be mindful of a couple things. Hopefully, when all of your employees started working remotely or on a hybrid format, you made clear to them that you still reserve the right to bring them back to the office, right? Because if that wasn't made clear, what could happen is the employee could say, well, now this is now part of my terms and conditions of employment that I work remotely. And I don't have to ride the GO train an hour each way from wherever I live to get to the office. And because then if you change the terms and conditions and say, well, now you have to work in the office, they could claim that's a constructive dismissal, because a constructive dismissal is a significant change to the terms and conditions of employment. But if you made clear at the outset, especially if you said that this is temporary, or, you know, we're trying this out, or at any point we might have you come back to the office, then the employee shouldn't have that argument, because the terms and conditions of the employment contract were clear. Now, all that having been said, it wouldn't surprise me if someday we see a decision from a judge, even with that kind of language, where an employer made that crystal clear that, hey, remote working or hybrid working, that's only at our pleasure and we can bring you back anytime. I could see some judge someday saying, well, you let them work from home for like 10 years and then all of a sudden you brought them back in. Despite that, you know, the judges have all sorts of creative mechanisms. They could say, you know, the substratum of that, you know, that one time they got rid of a termination clause that way. That was all part of that wasn't part of the substratum of the employment contract anymore. It all changed after 10 years of working from home. You're never going to know 100%, certainly. But then on the other side about, well, discrimination claim, harassment, as long as you're like solid on it, you should be fine. Like, hopefully you'll be able to point to some real like performance shortcomings, right? That you can articulate and explain if you ever had to appear before the Human Rights Tribunal or in court, why that employee was now required to work in the office and everybody else in the department could work from home, right? Hopefully you've got the warning where you say, look, here was the issue. You weren't completing these projects on time. You know, you didn't follow the instructions. We found you were spending half your day not at your computer or not working. If you have that kind of stuff, then that should be a very good defense to that kind of claim. Could an employee allege it anyway? Yeah, they could. But if you've got good reason to do it, what I would say is don't be like subject to legal paralysis and paranoia, and not take any action because you're worried they might bring a claim, right? Because that's not a good way to manage your workplace. And in the end, it just comes back to make it worse. Because then if you don't do anything about it, then their performance gets worse, and then you finally do terminate. And then the employee says, well, you didn't do much about it, and you picked on me, so actually, you know, I think it was a discriminatory termination, and then you get human rights claims along with wrongful dismissal claims.
That's a good point. In terms of quiet quitting, some of the, it's not clear from the question here, but I think they're essentially saying that a number of folks are quiet quitting because they don't feel that they're being compensated appropriately. And in particular for nonprofits, but I would assume this applies for all employers. If you're not able to pay more, what are some strategies to address these concerns that you might suggest? Right.
Well, that goes back to what I was talking about earlier, trying to build engagement. I mean, for what it's worth, I'm not so sure money is a great incentivizer for engagement. I think it might be temporarily. But I think I've seen surveys that show of the things that motivate people in their engagement in their jobs, money is actually farther down the list. More important seems to be feeling they're part of a team, that they feel valued, that they are clear as to what their expectations are, and that they find the work itself interesting and stimulating. So I wouldn't despair if you can't pay as much as your competitor. You know, and I was actually talking to a lady at a conference last week for cannabis retailers. So she has a cannabis store in London. She has a couple of them. And I don't know if you know anything about the cannabis retail industry, turnover is like rampant. They have like 80%. I was hearing from them, they have an 80% turnover. because there's so many of these shops, they can go work anywhere. And not to overly, stereotype, but like the nature of the young demographic that works there, they tend to always have their eye out for, making an extra nickel an hour somewhere else. And she told me that she has not had a single employee leave in 5 years. And she said it's because she like values them and like gets to know them, gives them appreciation, does extra little things for them, has little events, stuff like this. And so anyway, I found that kind of interesting.
Sounds like they're getting high on their own supply.
No, she actually made clear to me she's never used her product. She said
There's
never
probably
used.
a rule about that somewhere. All right. Right. So we've got a few questions that are sort of more focused on privacy, but I think it's probably still worth discussing in the sphere of quiet quitting. So if an employee uses their personal device for work email, can the employer use these emails, these work emails, I guess, against them in sort of performance management for quiet quitting, since the employee will also use it for their personal emails and other use? Is there anything to watch out for, I guess?
Well, I mean, if the issue is that the employee's not working or their work emails are terrible and then not meeting the standard performance, the fact they're using their own device for the emails is irrelevant. I mean, if the question is, can you monitor those emails? Well, if they're using like their Gmail account, personal Gmail account for work emails, I mean, that could be a problem. I wouldn't recommend that. I think you'd want all of your employees using your server or your work email account so that there's that clean line between personal and work emails. So to the extent they're using your work email account, well, whatever is in there is fair game, and hopefully you've made clear that they can be monitored. And maybe if you find like in your work email account, you find inappropriate personal emails, we all know what that can amount to. You might even have dealt with a few of those situations yourself. Then by all means, you can discipline or terminate an employee for that.
Okay. Well, I think that takes us to the end of your session, Landon. Thanks very much.
Thank you.
I'd like to welcome to the dais my friend and partner, Jeff Murray, who will talk about the significant changes that have happened over the last couple of years in employment standards.
Morning, everyone. Is this the thing, Jeremy?
That's the thing.
That's the thing.
It doesn't need line of sight. You can just click it from over there. I think it's Bluetooth.
No, I want to see what slides up, though.
No, I mean, like, you don't have to
I don't have to point it at the
the
thing?
screen.
No, I'll just point it at you.
That'll work.
Okay. So thank you very much. Thank you, everyone here who's here presently and people who are present online. It's always great to have an opportunity to speak to you about issues that are on the cutting edge of labor and employment law. And when we started off designing the conference this year, we noticed that a constant thread running through most of the topics to some extent was the Employment Standards Act. And this was sort of surprising in that for those of you who've sort of been practitioners for a while will attest to that there once was a time when the ESA was really just sort of a niche piece of legislation that set out hours of work and what the entitlements were for relatively low wage employees. And the common law courts were really the place where all the action was. That's where the wrongful dismissal litigation happened. That's where the whole concept of constructive dismissal came out. That's where you'd have to go in order to litigate restrictive covenants such as non-competition agreements. And the ESA was just sort of this tangential sort of afterthought piece of legislation, which really, I can't even say it was the blue collar piece of legislation. It was sort of the no collar piece of legislation. And over the past 10 years or so, we've seen a remarkable awareness of the ESA, both from the government, which is using it now as a vehicle to make very significant social changes, and also of the courts, who are paying much more attention to it. Principally, as Allison spoke about this morning, and the whole titanic struggle dealing with the enforceability of employment contracts. The ESA and the interpretation of the ESA has played a primary role in all of that. So we're very much in a new era when it comes to the ESA. And so just a case in point this year, and this is, this is only over the past 12 months, we've seen significant amendments to the ESA, particularly with two pieces of legislation known as the Working for Workers Act 2021 and the act they liked it so much they named it twice, the Working for Workers Act 2022. And before I even launch into this, I want to say that this legislation is poorly worded. As you'll see, it really should be known as the Working for Middle Managers Act. Because it is those people who are really benefiting from the changes that the government has implemented through this legislation. But we'll talk about the Working for Workers Act 2021 and the elimination of non-competition agreements and the requirement that employers now have policies concerning disconnecting from work. And then the Working for Workers Act 2022, which deals with policies concerning electronic monitoring, a topic Landon was just speaking about, and also the enactment of specific protections for digital platform workers who till now have kind of fallen into sort of an ambiguous area of whether they are employees regulated by the ESA or strictly independent contractors with no rights at all other than those prescribed by contract. We'll also talk about case law developments, particularly two very interesting cases whereby, or two interesting topics. The first is one the courts have been struggling with to decide whether an employee that was placed on layoff at the time of the pandemic commencing is entitled to sue for constructive dismissal, notwithstanding the fact that the province enacted something called infectious disease emergency leave, which on its face appeared to suggest you couldn't sue for constructive dismissal. And the second case is a decision of the Ontario Divisional Court, which said the way the OLRB and courts thus far have been interpreting the whole severance pay obligation is wrong. And the obligation to determine whether an employer's payroll is $2.5 million or more isn't just restricted to what you're paying people in Ontario, but what you're paying people globally. And both of these cases, I think, indicate a real enthusiasm that the courts have to breathe a lot of life into what they see as benefit conferring legislation and to apply what's known as a large and a liberal interpretation to the ESA. So, Working for Workers Act 2021, the non-compete prohibition. This does what it says it does. It prohibits employers from entering into, and I emphasize those words for reasons I'll discuss later, entering into non-compete agreements. Those agreements are defined as any agreement that prohibits the employee from engaging in any business, work, occupation, profession, projects, or other activity that is in competition with the employer's business. So we all know what non-comp agreements are. They basically are things you try to get people to sign when they start working for you, whereby they agree they're not going to go and cross the street and work in competition. Allison's comment about dentists is particularly apropos. This is something you often see in professional practices. The junior dentist can't come in here and get to know all the patients and then open up a shop across the street. These contracts have been around for decades and decades and decades, but now in one fell swoop, the legislature has deemed them to be unenforceable, quite surprisingly. Now, there are some exceptions to this. They are narrow exceptions, so you can still enter into a non-competition agreement with C-suite employees. These are, quote, executives or people that you enter into the non-competition agreement with upon the sale of the business. So if you're buying a family business, you're a conglomerate, and you want the principal to be around for a while, but you don't want him or her then, opening up a competing business, that kind of non-competition agreement is allowed. And also senior people in your organization. And these are defined using specific titles. So chief executive officers, chief financial officers, chief administrative officers, chief human resources officers, the president or other chief executive positions. I imagine that anyone who is now going to be hired into an HR position is now going to be hired into the position of chief human resources officer, just so that a non-comp can apply. So there is, I expect there's going to be a bit of title inflation. But the fact that the legislation specifically refers to someone in a chief executive position, I think really means if you are the last person on the top rung of the ladder for a specific function, that probably will allow your employer to require or at least ask you to enter into a non-comp. Everyone else underneath that is these agreements are now of no value. Concern, the way non-competition, non-compete has been defined rather broadly. Actually, I'll go back to my previous slide. Theoretically, it prohibits anyone who does work or other activity that's in competition with the employer's business. Query whether this actually then applies to non-solicitation agreements. Those are agreements whereby the salesperson or person with close customer contacts aren't allowed to actually solicit business away from the organization. We can certainly see that at some point, some enterprising lawyer is going to say that it's not just the non-comp that doesn't apply, but the non-solicitation agreement, because of this very broad definition. For now, I don't want you being particularly alarmed by that, but this is certainly something we're going to be watching in the years to come to see if that case does show up. Silver lining here is that the prohibition against non-comps does not apply to non-competition agreements entered into before this legislation was passed. The language of the amendment specifically prohibits the entering into of an agreement, and that has been interpreted, fortunately, by the Superior Court and the Court of Appeal as meaning that the old rules apply to non-comp agreements that existed prior to this amendment. Now, silver linings can turn to tin pretty quickly, and I'm curious to see, again, as time goes by, whether courts are going to be more and more restrictive in how they interpret legacy non-comp agreements, because as we know, for decades, the courts have said, well, we're not going to enforce all of these things. It has to be limited in scope of duties, limited in geographic scope, and limited in temporal scope. And I just wonder whether the courts are going to see this legislative policy announced essentially through the passage of this legislation to say, well, legislative policy is that these aren't good things. And so we're going to be much more restrictive than we previously were. And we're going to try to simply interpret away all non-comp agreements. Again, this is one of those watch this space comments, but it's an interesting space to watch. The second significant employment law, and I know Ryan spoke about the occupational health and safety angles of this, but from an employment law perspective, is the enactment of the requirement to have a written policy concerning disconnecting from work. Disconnecting from work means not engaging in work-related communications, including emails, telephone calls, video calls, or sending or receiving other messages such as smoke signals, so as to be free from the performance of work. So pretty broad. If you are an employer as of January 1 in any year that has 25 or more employees, you have to have this policy. Ryan made the point that we've seen occupational health and safety legislation for a number of years require employers to have a policy on certain things, harassment in the workplace, violence in the workplace. So this in itself is nothing new. However, what's most interesting about this provision, it doesn't indicate what the policies are supposed to say. It doesn't say you're supposed to prohibit employees from working or require them to disconnect. You simply have to have a policy about disconnecting. So the smart aleck in me, and I certainly don't give this advice to clients, but the smart aleck in me says, well, you can actually have a policy that says our disconnecting from work policy is that you need to be online all the time and check your email every 2 hours, even at nighttime. Now, clearly, this is not what anyone's going to do, and it's clearly not what the legislature intended. And I think what this signals a sort of a very clever change in the mind of government, that what it's trying to do is conscript the consciences of corporations, to force them to do and say something on a topic they want them to do and say things on, and rely on them to do good and act in good faith, because it's a very rare corporation that's going to be forced to have a policy on something that actually isn't intended to address the actual needs that the employees have. So it's kind of a way to almost outsource the creation of rules to employers. You make your own law, but it's got to be on this. And I think this is a very interesting legal tool in the toolbox that we're going to see in years to come. And it seems like the Employment Standards Act is the vehicle through which this is going to happen in employment. No consequences for employers that violate their policy. And no need to actually have an enforcement mechanism. So it really is kind of a hollow obligation relying on the good faith of all and sundry employers. So that was all great at the end of 2021. It was so good that the Ontario government, heading into an election year, decided that they would enact the Working for Workers Act 2022. And they decided that now they would come up with a new obligation to create policies, this time concerning monitoring employees. And this is something that Landon, of course, spoke about a moment ago. And again, it applies to employers with 25 or more employees that now must have a policy concerning electronic monitoring. Obviously, the purpose of the policy is to increase transparency in workplaces by requiring employers to disclose if and how they track the use of electronic devices, such as computers, cell phones, GPS systems, and other devices. Very broadly defined electronic monitoring in this legislation. So to summarize, the policy has to address whether in fact you electronically monitor employees, when and how you monitor the employees, and the purposes for which the information obtained through electronic monitoring may be used by the employer. And on that latter point, the obvious answer is to make sure people are doing their work. That's the only reason why you would electronically monitor employees. And so you're going to have to say what it is you probably never wanted to say if you are using these mechanisms or these tools. And people need to know that you're doing it. A question that obviously leaps out is, who asked for this? Where was the clamor? Where was the protest at Queen's Park with people saying we want an electronic monitoring policy for our employer to release on January 1st every year? Nowhere. And so here is my theory about where all of this came from. Landon spoke about privacy interests, and he was very careful in the terms he used, because in Ontario, we don't have a privacy law, right? Quebec has one, Alberta has one, BC has one. And a couple of years ago, the Ministry of Consumer and Commercial Affairs set out this white paper that said, hey, should we have a policy, or rather, should we have a privacy law in Ontario? And then it kind of went into the bureaucratic black hole, and we never heard anything of it. And these are the kinds of things that would be affected by a privacy law. And so what I think this is an attempt to have employers again create their own legislation concerning workplace privacy without the legislature forcing the specific obligations on the employers. That's just a theory, but I think it's got a good possibility of being correct. Now, when this all came out, there was a lot of confusion and uncertainty and twiddling of thumbs about, oh, what are we going to do? So the Ministry of Labor set out a guideline about what it wanted employers to do. Again, this is not law, but it's a guideline from the ministry about what they think people should see in an electronic monitoring policy. I gave an example of what electronic monitoring is: GPS to track workers, electronic sensors to track productivity. They even gave the example of a checkout counter where you record the number of transactions a minute or hour, tracking of websites. But they also made very clear that these amendments don't establish the right not to be monitored. They don't create any new privacy rights, and they don't restrict the employer's right to use information obtained through electronic monitoring. So instead, and I think it's probably better, frankly, than going down the Quebec, Alberta, British Columbia road of having a privacy law, or federally a privacy law, to simply say that you guys get to make the rules, but you have to at least tell people how and whether you are monitoring employees electronically. So the next aspect of legislation that came into effect is the Digital Platform Workers Act, actually not related to the ESA, but kind of rhymes like the ESA. It's sort of a similar thing, setting out minimum standards. I just wanted to give you the background to this law. There's a class action that is worming its way through the Superior Court in Ontario, filed on behalf of Uber drivers, whereby they're seeking, or suing rather, for non-compliance with the Employment Standards Act. So didn't get minimum wage, didn't get holiday pay, didn't get vacation pay. And when this lawsuit arrived, Uber said, well, it can't proceed because we have an arbitration agreement. You can't go to court. And it produced the arbitration agreement that said if any Uber driver in Ontario has an issue with Uber and their rights, well, they've got to, pursuant to the arbitration agreement, file a application for arbitration at the International Court of Arbitration in The Hague, Netherlands, and pay $14,500 for the privilege. No one obviously did that. And the lawyers representing the Uber drivers said, well, that's ridiculous. So we want, Uber said the whole lawsuit should be stayed because of this. And the Uber lawyers, or rather Uber driver lawyers, said, no, that's crazy. You shouldn't apply this arbitration agreement because it impedes access to justice. The whole case got litigated up to the Supreme Court of Canada. And not surprisingly, the Supreme Court of Canada said you can't force people to go to a foreign country because they feel like they should have got that right as opposed to someone else. And particularly when these people earn around $14,500 a year. So that lawsuit is now back on, and Uber's got to deal with it. And I don't think coincidentally, within 12 months of this judgment being released, we see this new legislation enacted, which is basically, I think, designed to fill a legislative void. And the reason why that void needs to be filled from Uber's perspective is because if there's nothing there that provides any legislative rights for these employees, the employees are going to be able to say, well, you're basically sending us back in time to a period before the Employment Standards Act even existed, and everything is just based on contract. And we've seen a precedent from the Labor Relations Board in Ontario, whereby another digital platform operator, Skip the Dishes, has been found to be an employer in accordance with the dependent employer definition of the Labor Relations Act. And so I think as a result of significant lobbying by Uber, the province took action to create this sort of parallel but somewhat non-employment related rights conferring legislation. This legislation for these workers has some minimums set out. There needs to be a regular pay period, information about how tips are calculated and assignments are given, how reviews take place, and performance ratings has to be shared. There has to be a minimum wage for each assignment. It's not a minimum wage per hour, but you do have to say there's a minimum charge per assignment. There has to be 2 weeks notice before someone gets kicked off the platform, unless there is proof of willful misconduct, a word that is haunting employment law practitioners, as you will hear further today. So this is an interesting attempt, again, as I say, for the legislature to try to fill a perceived gap in employment law, like all of this legislation has been intended to do. It's interesting now that governments of all political stripes are identifying as pro-worker, and many of these changes, I have to emphasize, are unnecessary and unwanted. No one asked for the elimination of non-competition agreements. No one clamored for legislation concerning employer policies on the right to disconnect. But the ESA is a very fertile ground for political action by governments that want to be seen to be pro-worker. And I think that's what's happened. And I think we're going to see this story replayed over and over again. So that's the legislative developments concerning the ESA. There has been some case law developments, and two particularly. The first dealt with infectious disease emergency leave. This was a specific leave that was enacted at the outset of the pandemic, where the ESA specifically said that where employees are placed on layoff and can't be assigned duties, they're actually not laid off, but they're on a job protected leave. The legislation also said that the employee cannot file a, quote, complaint for constructive dismissal. And this legislation ultimately was revoked this summer. Thank you very much. Jeremy? Now, you probably know that at common law, a layoff is considered to be a constructive dismissal unless the employer can specifically prove that there is an expressed or implied right in the contract of employment to lay the employee off. And that is authority for that is a case called Chen versus SigPro Wireless from 2005. And so there was debate in the legal community about whether that precedent would be followed by the courts to allow employees that were told you're laid off while we sort through this whole pandemic situation entitling you to common law notice, whether that precedent would be applied, notwithstanding what was written into the IDEL provisions of the ESA. Case law has been split on this. The first case to decide it occurred last year. Is a case called Coutinto versus Ocular Health Center. And in that case, the court held that the deemed IDEL provision did not affect the right of an employee to be placed on deemed IDEL. And it allowed them to sue for constructive dismissal. And the court said, well, you know, I'm looking at the ESA here, and it specifically says that nothing in the ESA affects the civil rights of employees. And I say the term civil rights in the Canadian context, which means your civil law rights. And therefore, this lawsuit can go ahead. And that case was followed without much analysis in a case called Fogelman. Was not followed by a judge of the similar court slightly later in 2021, where that decision was rejected by a court that basically kind of took a common sense approach and said that you can't be both on a leave of absence and laid off at the same time, and to hold otherwise would render these IDEL amendments to be meaningless and would result in an absurd result. And to quote the judge in Taylor, the employee cannot be on a leave of absence for ESA purposes and yet terminated by constructive dismissal for common law purposes. I'd suggest that that's simple common sense. And the judge said that, as we now know, the legislature can contract out of the common law. And that's clearly what it did to deal with a very specific emergency and problem facing employers. And so here we had sort of a clash of the titans between two Superior Court judges that saw things very differently. And the case goes up to the Ontario Court of Appeal, who ultimately evaded the issue by deciding the appeal on a procedural basis. And so we're now at a situation where the courts are divided on whether this is a constructive dismissal or not. I think what it demonstrates really is a very strong reticence on behalf of many judges to do anything that interferes with the rights conferred by the Employment Standards Act. They almost take a kid gloves approach to any right that's established in the ESA, and they don't want to do anything in the absence of absolutely crystal clear legislative intention to change this legislation, which I would suggest has now almost become quasi-constitutional in application. I say that a bit tongue-in-cheek, but I don't think it's too much of an exaggeration. The last case that I think is interesting is the case of Hawks versus Max Eicher, North America Limited, which dealt with whether the threshold for an employee being entitled to severance pay under the ESA is based on the employer's Ontario payroll or global payroll. And just as a recap, everyone in Ontario has an ESA right to notice of termination, i.e. in this letter, I'm telling you you're fired in a certain period of time. That's notice. But other employees that work for larger employers are entitled to severance pay, which is a cash payment. But that only applies if the employer has a payroll of over $2.5 million. Now, that was a lot of money when this came into effect I think it was in the early 80s. The $2.5 million threshold has remained constant, so it's not as much money this year, and it's definitely going to be a lot less money next year. And for decades, this requirement has been interpreted by the courts and the OLRB as basically being your Ontario payroll, on the kind of logic that this is, it's Ontario legislation, and how do you figure out whether somebody's payroll in New Jersey is $2 million and you add that to the Ontario payroll to cross the $2.5 million threshold here. The divisional court, and I rarely say this, but poo-pooed that interpretation and basically said, the law doesn't say it's Ontario payroll, and therefore it's just your payroll. And here they were dealing with a very large European steel company that obviously had a payroll over $2.5 million. And so Mr. Hawks was entitled to his ESA severance pay. An interesting implication of this, obviously, is these conglomerates run themselves through a number of corporations, right? There's ABC Corporation Canada, there's ABC North America, there's ABC Europe, and all of the related employer provisions of the ESA would allow the pooling of this payroll figure into one total global number. It'll be interesting to see how vigorous the Ministry of Labor becomes in trying to determine what global payroll is. But essentially now the way things always were is no longer the case. And again, here we have a group of Ontario judges that have taken a very broad and expansive interpretation to the ESA for the very reason that it is benefit conferring legislation intended to benefit employees. So, closing thoughts. The ESA is not your parents' ESA. It is now one of the gleaming pillars of Ontario employment law. The government is using it to change very important parts of the common law, address technological change, influence employer policy making, and essentially to make political points with the electorate. The courts are very deferential to the ESA and apply both restrictive interpretations or expansive interpretations depending on the circumstances and it'll adopt a restrictive interpretation if that's going to benefit employees, and they're going to adopt an expansive interpretation when it will benefit employees. And so, watch this space. Thank you very much. I understand we have some time for questions.
So a few of them will come in from the earlier part of the presentation, so I'll give you some of these ones first. So what if an employee has an executive function but doesn't have the word sort of chief in their title? Will they be lawfully subject to a non-compete?
So I'm going to be honest with you and tell you that I don't know. I will tell you that the executive is going to say they're not C-suite, and therefore this doesn't apply to them. And they're going to rely on the term in the amendments that refer to people in a chief executive position. Now, I think that the courts are going to breathe a little bit of life into that exemption if you can show that you really are, or that the employee really is at a senior level and is the one in control of this particular function. So consider the family business where you've got the president of the company, and then you got the accounting manager who's actually not the accounting manager, but really the CFO controls all the finances of the company. I think the company is going to be able to say, well, we never called George the CFO, but if you look at what he did, he was the CFO. And so I think there will be a purposive interpretation, but you're going to have to be able to show that the degree of responsibility and autonomy that this person had was very high.
Point. Onto the electronic monitoring. Would security cameras be considered electronic monitoring, and would the existence of those need to be included in the policy?
I think absolutely. Most security monitoring cameras are known to people, but I think you have to put that in the policy, and you have to say why you're using the security camera. And here's an interesting question. The primary purpose, of course, is to protect the well-being of people in the building and the perimeter of the building from the physical plant being secure. But many employers do rely on these cameras to monitor performance. In accordance with the law, you're going to have to say that in your policy. Now, the question then becomes, What if you don't say that in your policy? Are you going to be able to rely on it if you ever have the court case or the human rights application where you're saying, well, we terminated the person because they were stealing, not because they were left-handed? That will be an interesting decision for a tribunal to make. And I think the actual wording of the legislation does say that it doesn't create rights and there's no consequence for not following the policy. And so that evidence becomes admissible, and the only consequence is a finding under the ESA that your policy was not as comprehensive as it needed to be.
So this question sort of is bootstrapped to that one from another attendee, though. They're curious about the type of damages, or I suppose other relief, that an employee could claim for if they're being asked to work at times that the policy would permit them to disconnect.
So I don't think this actually changes anything already in the ESA dealing with hours of work and overtime. If the person has worked more than 8 hours in a day, and there are exceptions to this, managers are the obvious ones, then they're entitled to overtime. And the definition of work in the ESA is where work is done or is suffered to be done. And that language has been interpreted to apply to people that have been told, you're not supposed to work after 5 o'clock, so don't. And even when they have been told that and still work after 5 o'clock for 12 hours in the day, there is, so it's 44 hours in a week. So if all that adds up to more than 44 hours in a week, you still owe that person overtime. And to some extent, therefore, it's useful to actually embrace this policy because it makes clear what your expectations are for people. And hopefully they won't put in these hours and then present you with a very hefty overtime bill a month later or, 2 months later.
Sort of an interesting question here, splitting hairs. Is there a difference between having the capacity to monitor, where we could look if we wanted to, or actually engaging in that monitoring? Do we have the obligation to let people know what we could do, even if we're not actively doing it?
So, Jeremy, are you asking me about the tree and the forest? And
this is Kim.
Okay.
This is Kim asking you this question.
Okay.
So
I don't believe that. I think this is actually one of those fake questions you put forward.
It's here from Kim.
Okay. So
it's right there.
If you have the capacity to monitor, but you're not monitoring, you don't have to say you're monitoring because you're not monitoring. Like we have the technology, okay, but are you using the technology? And unless you're using the technology, you don't have to include that in the policy.
Okay. And another question here. Is there an obligation to disseminate the policy that you have drafted on disconnecting from work, or can you just have it and leave it in the binder on the shelf?
Well, that's a good question. That actually was in my notes, and I kind of gleaned over that. You do have to share the policy, both the disconnecting from work and the electronic monitoring policies. If you have 25 employees at the start of each year, you have to have a policy. Now that meant for the I think it's the disconnecting from work policy had to be shared with employees by June of this year, and the electronic monitoring one had to be shared, has to be shared by November 11th or November 22nd, in any event this month. So it does. Once it's there, new employees have to get copies of the policy within 30 days of starting. And if you change the policy, everyone has to get an updated version of the policy within 30 days. I see some heads nodding, so I'm taking comfort in the fact that I think I got that right. People are too polite to tell me no, so we'll ask for the next question.
Okay. Sort of an esoteric question, which might be interesting to get your take on. If Uber loses this class action, that you referred to, do you think that'll have a chilling effect on the gig economy?
I think it'll kill the gig economy. I think if you can, if I think it will kill it because the market will no longer be able to bear it. The reason, and I'm not an economist, I'm not an expert on this, but what it will require is a minimum wage for all time you're behind the wheel. It will require overtime if you work overtime. That will require Uber to put in some very rigid rules on when you can actually log on and be driving Uber. That won't be appealing to people that have gravitated towards being Uber drivers. It will also require Uber to recoup the added cost of the minimum wage, the overtime, the holiday pay, the vacation pay, the severance pay, the termination pay. And the price you're going to pay for an Uber is going to be pretty close to what you're paying for a taxi back in 2018. So I think it's just going to kill at least the ride share. Some people will always pay to get a gourmet meal delivered to their house or apartment, but it will certainly shrink the market concomitant with the transaction costs.
We also have we have a couple minutes, and there was a question asked about sort of the. I'll frame this as a general. What are the rules in terms of when an employee is entitled to severance pay under the ESA? Just there's some clarity I think this person is asking for there.
Okay, so under the ESA, termination costs have two broad sources. One is common law notice, and the other is entitlement under the ESA. What you pay under the ESA is set off from what you have to pay for common law, and it's almost always the common law bill is more than the ESA bill. But many employers have these great contracts that me and Landon and Allison have devised to try to insulate you from the common law, and Jeremy, to insulate you from the common law costs. And so if that's you, everyone gets notice, which taps out after 8 weeks. Do you owe severance pay? Well, that's in two circumstances. One is where the employee works for an employer with a payroll of more than $2.5 million and has more than 5 years service. And that's generally what you're going to be thinking about in deciding whether you owe severance pay. There is a further entitlement in cases where there is a permanent discontinuance of all or part of a business, whereby I believe it is 50 or more employees are let go within, I believe, a 4-week period of time. I see someone nodding over there. Yeah. And in that situation, you also owe severance pay, even if you're not a $2.5 million employer. Now, obviously, it's only employers that have a payroll of over $2.5 million that have the size to lay off more than 50 people in a 4-week period. So to some extent, it's a bit moot, but it is a wrinkle to be mindful of when you are. And let's face it, we're going into a point in the economic cycle now where downsizing is something we're going to be talking about. So that's a legitimate consideration. Certainly, if you are planning downsizing in the year to come, you need to contact your labor and employment lawyer because doing that wrong can be incredibly expensive. And so that's one of the things that really has a big impact on liability. And it's an area that's quite treacherous, and mistakes can be made, and we can help you with that.
Thanks, Jeff. So that's all the time we have for questions, and we've now reached our lunch break. So our lunch break runs from now until 1:15. So if I could ask everybody to go out and eat something, so you come back ready to go for my presentation on the enforceability of COVID vaccination policies at 1:15 p.m. It's going to be great. I'm going to make vaccination policies great again. That's going to be mine. All right. Have a good lunch.
I'd like to introduce our first speaker this afternoon, my partner Jeremy Schwartz. As some of you may be aware, Jeremy recently appeared with Ryan Conlon at the Supreme Court of Canada, arguing a very important case on health and safety liability. But that's not what Jeremy is here to talk about today. He's going to be talking about COVID vaccination policies, which I think most of you have had at least some experience with, so you might be curious to see just exactly what has been going on. And, you know, a year or two ago, we were talking about, well, when the cases start to come out, here's what we think might happen. Well, guess what? We've had some cases, so Jeremy's going to talk about them.
Thanks, Len. Glowing recommendation. Everybody's going to glued to their screens. So I've been using this quote since the beginning of the pandemic. When I talk about vaccination policies, because I think it sort of sets the framework for how we all initially thought this was going to go. So this was a statement by Christine Elliott, then Minister of Health, saying there may be some restrictions placed on people that don't have vaccines for travel to be able to go to theaters and other places. And it'll be up to the individual person to decide whether they want to get the vaccine in order to get access to these opportunities to travel and go to the theater and such things. And there was a clamor among employers for some guidance here, right? We wanted to know not just, is this part of the general duty clause, right? We have to take all precautions reasonable in the circumstances to protect our workers. We wanted to know, do we have an obligation to test? Do we have an obligation to require people to vaccinate? Do we have the right to require people to submit to testing, to submit to vaccination, and to impose consequences where they don't? And of course, we didn't really get a lot of help, especially in the first year or so. I won't get into the political aspects of that, but I think that's an unfortunate failing of the stewardship of our officials during a time when it would have been nice to have some guidance. If we look at the sort of overall important time horizons, I've sort of picked my favorite dates that I think are important. I lifted this from a similar list that Jeff had in a presentation he's done recently. So I wanted to thank Jeff for helping me with these. I'm not sure where he found this important information, but it's great. I put it in the pretty slide. Okay, so I made it look good, but he found the information. So as you can see, we sort of start in January of 2020. We make our way all the way until March of 2022. And here are all the sort of general dates that are important. Most importantly, of course, for the vaccination discussion is we didn't really have a viable vaccine that had been approved for adults to use until really the end of 2020. Okay, so even though that's an awful lot of time not knowing, it's an awful lot of time during which employers might have been thinking about what will we do when the vaccines are available. Some employers took a proactive approach, many didn't, and they waited in the hopes that once vaccines were available and proven to be safe, that they would get some guidance on what to do with that. So where do we stand in terms of vaccinations? If we were looking at this table, which comes from Statistics Canada, from right off their website, I just sort of copied and pasted an image of their download. As of October 9, 2022, people who are 12 and over have had 88% on average, Canada-wide, have had the first course. Now, the science seems to be suggesting that course that they took, number one, was to deal with variants that are really not common anymore. So who knows if they're efficacious at all anymore. And these vaccines might not actually remain effective for very long. There's differing science on whether, sort of the highest level of protection is only for a few weeks, and then perhaps still having some remnants of protection may protect you from long COVID or some of the more severe symptoms. We really don't know. But these are the people who have had sort of the first two shots. Now, those numbers decline significantly as we look at the other tables I'm going to take you through. But I want you to cast your mind back to December of 2020 through to sort of the middle of 2021, where there was this real fear about the pandemic. People were not able to go to work. We had shutdowns And it was really wreaking havoc on our lives and the economy. So we have a much better uptake. People were willing, almost 90% of adults were willing to get the first course of vaccines. So when we had employers like the federal government imposing vaccination, it was for the outlier. It was for the 10% or the 5% of people who could get it medically, but who just really didn't want it. And there was a question about whether it was right to force them, but there was also a scientific question about whether it was necessary. If you have 90 to 95% of your workforce already vaccinated and the population is already at 90%, can you reach herd immunity or close to it at that point where it's no longer necessary to protect people by forcing them to inject a foreign substance, right? But then what happens when we start looking at the additional series of vaccines? So this is now, right? So if we're considering what to do with our vaccination policies now, we're no longer doing this in an environment where the majority of Canadians, almost all of Canadians who are of working age, are vaccinated. We've got less than 50% of people who can get vaccinated have had one booster shot. And if they had that booster shot more than 6 or 8 weeks ago, it's probably not doing anything for them anymore anyways. And if you look at people who've received 2 booster shots, the numbers go down to not even 15%. So we're now in a stage where we're not even close to herd immunity. It's almost irrelevant whether people have had shots. Might be more important if they've had COVID and have some immunity that's built up as a result of that, some antibodies. But the science says somewhere between 90 and 95% is required for herd immunity. So this is irrelevant, 15%. It's nice. It might help you personally, but it's probably not going to save people who have not gotten vaccinated, whether because they choose not to or because they can't, from getting COVID or from having serious and potentially long-standing side effects. So mandatory vaccination policies. This was a decision in January of 2022. And I'm going to talk a little bit more about the facts that come out of it, but I wanted to first talk about this one paragraph that comes out of the decision. So what constitutes a reasonable mandatory vaccination policy in the course of a pandemic is contextual, and this is what I would underline, highly dynamic. In such an environment, both the overall circumstances in the community and the circumstances of the particular employer take on great significance, while precedents decided in a completely different context, even as recently as November of 2021, and I'll talk to you about why this case is only 2 months after another case and completely different things were decided, necessarily become less relevant than they might otherwise be. So what is this arbitrator saying? They're saying the day you come to court matters. The facts matter. Your industry matters. The kind of COVID we're dealing with matters. The stage of the pandemic matters. And all of these things have to be in the employer's calculus when it decides whether implementing a policy, amending a policy, maintaining a policy, or rescinding a policy is the right thing to do in their circumstances. And just because you had a policy last year that in those circumstances was reasonable and would have withstood challenge doesn't mean keeping the same policy as it was last year is valid and justifiable now, and vice versa. Now, we did get a little bit of guidance, so I was slightly unfair when I said we didn't really get much, but I don't think I overstated, really, because we got a regulation which said if your local chief medical officer of health says you have to do something, issuing a requirement or a direction, or even making a recommendation in writing, then you had to follow that policy. And so if your local chief medical officer of health said you have to have a vaccination policy, and that policy should say either get vaccinated or you have to test and validate and disclose your status, then you had to implement that during the very brief period of weeks that there were any chief medical officers of health that were requiring this, including in Toronto and a few other places. And the chief medical officers of health didn't get the memo. Okay, so my office had to contact, and Hadi at the back there, my associate in one particular case, actually had to get in touch with one jurisdiction. I won't single them out. And they were, I don't know what the best way to put this is. I don't think they were prepared to answer a clear question. So they had issued a direction. It was old. And we wanted to know, is this a requirement or recommendation that we are still obliged to follow as an employer in your jurisdiction, pursuant to this regulation. I think Hadi wrote a very clean and simple email. You couldn't get, it's either yes or no. There was no in between. Took them a couple of days to get back to us. They finally did, and they said, no, it's no longer in place. Okay, fine. The fact that it wasn't clear and that they weren't communicating in an effective way meant that this nice idea wasn't really helpful. Okay. And it also didn't contain any provisions that officially said, employer, if you implement these things, that you have the rights to impose consequences for employees who don't comply. You can implement a policy. That doesn't necessarily mean you can discipline for violations. That wasn't in the regulation, right? So again, we did have a number of local health units that put out some information, have different rules, but generally speaking, all of these recommendations, to the extent they were put out by the local health units, have all been rescinded at this point, to a large extent. There are some exceptions in the healthcare sector and group home settings, but other than that, pretty much across the board, you don't have to put a mask on. You don't have to ensure vaccination among your employees. It's your choice. As an employer, you decide what's right for your workplace. All of this is happening in the context of this backdrop of human rights jurisprudence and privacy jurisprudence, okay? From a human rights perspective, there are particular grounds, and this isn't a presentation on all the human rights grounds that can apply, but essentially the main two that would apply to prevent an employee from being required, like they would have an exemption, would typically be either a medical one, right? Or it would be related to a bona fide creed or religion as an exemption. And there really wasn't a lot of case law on this before COVID. There was some case law on disabilities, and in general, you would have to have a medical doctor who would verify that the taking of the actual vaccine was in some way contraindicated for your condition. It would be dangerous for you, or you were on medication that you couldn't also take while you were taking the vaccine, things like of that nature. But from a religious perspective, we really didn't have a lot of case law on this. So initially we had guidance from the Human Rights Commission, which is, some of you might remember, 20 years ago now-ish, a little bit less. They changed the system so that we have our Human Rights Commission and we have our tribunal. Litigation goes to the tribunal, and the commission sort of still has a public policy role, providing guidance to the community, and they do have the ability to themselves initiate a complaint. But here, they're in their public policy hat. They're trying to give some indications as to how the law should work under the Human Rights Code. And they actually, in my view at least, put out a fairly reasonable, middle-of-the-road, detailed explanation of why, in most cases, employers can determine if it's right for them to promulgate one of these policies, and it won't violate human rights law as long as you have exemptions for people who have valid human rights grounds. If you want to go and read their dissertation on this, feel free, or you could just take my word for it. They were middle of the ground. They didn't come out and tell you not to do these things or that it would be a violation of human rights. Keep in mind that the definition of disability is one that has been subject to some litigation, but you must have a clear medical condition of some permanence. It's verified by some sort of medical practitioner that's recognized to demonstrate that you indeed cannot take the vaccine, or that it would be contraindicated with your condition or other medication. So the College of Physicians and Surgeons sent out advice. They told their doctors, don't write notes that say you don't have to get vaccinated for medical reasons unless you're sure, because it's actually less safe to tell your patients not to get a vaccine that could save their life or the life of the people around them, because of things that are really not valid medical concerns. Sounds like what a doctor should be doing. Sounds exactly the opposite of what usually happens when we get the one-off doctor's note that says off work for medical reasons and no information about what their restrictions are. But in this case, the actual college said to these doctors, don't. So what happens? A number of doctors, of course, started just handing out their prescription pad and telling employers that people had exemptions. And true to its word, the college did initiate regulatory enforcement and disciplinary proceedings against a number of doctors. A few of them you can read publicly that they were actually subject to discipline, to suspensions, and I think in one case they actually lost their license. So they meant it. So that's good. But what happens if employees, now that we're sort of phasing back into the workplace and nobody's vaccinated anymore, at least not that matters, what if someone says, I don't want to come back, I'm scared? So they vaccinated. They might have someone who's at home who is vulnerable, or they have an elderly parent that they have to take care of, and they're concerned that the absence of vaccination in the workplace and the community at large means that they would be more likely to be exposed to COVID in the workplace. Well, the Ministry of Labor doesn't seem, at least from anecdotal reports or from the reports I can find on their website, doesn't seem to be taking those work refusals based on what are ostensibly subjective objections seriously. But of course, the case law does say that if an employee can show for objective reasons that they are initiating a work refusal under health and safety law, for example, that you have an obligation to investigate, and you may have an obligation to take steps to mitigate and remediate those concerns. And if not to the satisfaction of the employee, you may have to call the Ministry of Labor and have them figure this out. Certainly call us if it goes that far. But in most places, we have heard anecdotally, and I think at this point it's fairly, we're all sitting in here without masks on, right? People are back at work. And although some people would prefer to be working remotely, in many cases, employers have just said, okay, time to come back, and people are returning. When you have an employee who raises a concern, it has to be an objective concern. It has to be a valid one. If it's a work refusal, even if they don't use the magic words, you still have to do an investigation and decide whether or not you need to tag the Ministry of Labor in for the dispute. But under human rights law, the analysis is a little bit different when it comes to things like religion and creed. So when you have a medical condition, you go to a doctor. The doctor is regulated by a college. The college says this is a valid medical condition. These are the reasons for which an employee can't get vaccinated or can't wear a mask or whatever. You get a doctor's note, it's clear, it's tested. You can always go and get a second opinion. What do you do when it comes to someone who says it's a matter of conscience? I am a practicing member of the church of whatever, and we believe that vaccinations which have been developed using fetal stem cells for aborted fetuses from the 1970s and 80s, that this is a violation of our religious beliefs because it condones abortion. Well, what do you do when that comes? So before the case I'm going to get into in a second, what I would have said is, well, the Catholic Church itself has said that as a matter of conscience, you, what's the best way to put this? As a matter of conscience, it may actually be your obligation to take care of your neighbor by getting vaccinated. It may not actually, it's not a condoning of something that happened in the 70s to use a vaccine that was developed from technology that developed over 50 years as a result of what had been done 50 years ago. And so it's not a condoning of that, but it may actually be your conscientious obligation to take this vaccine. So with that in hand, all these employment lawyers went out there and told their clients they're going to have to really muster some serious evidence to prove that they have a religious objection under the Human Rights Code that's valid. And I'm guessing that's what led to this case. So we have a nurse who is a member of the Latin Mass community. And I'm not familiar with it myself, but according to the decision, this is a fairly more stringent sect of the faith, I suppose. And as an observant member of that community, this individual provided affidavits from themselves. They had evidence from the clergy of their church, essentially saying what I said a moment ago. These fetal stem lines were developed from aborted fetuses, and it's a form of condoning these abortions by basically taking any of this medication that was derived from this. And this is our honest and truly held belief that it would violate the tenets of our faith. So this employer, armed with all the case law and good hopes and dreams of employment lawyers from the statements from the Pope's office, said, I'm sure something like, this is nonsense. Even the Pope says it's okay. This is just a subjective belief. Suspend them, give them some time to decide, and if they don't get vaccinated, fire them. That's my guess if I was a little bird in the room listening to that advice. Unfortunately, that's not the view of the arbitrator. So the arbitrator's view here was, since the griever holds a sincere belief with sufficient nexus to her creed that to get vaccinated would interfere with the exercise of her faith and her relationship with the divine, the griever is entitled to an exemption based on the provisions of the code on the grounds of creed, period. It follows that the griever was prima facie discriminated against when the employer applied its vaccination policy to deny the griever's requested exemption. So there were a bunch of cases on masking. There were a bunch of random cases on people making political or saying, I didn't, it's a violation of my creed, my deeply held belief, because I don't think it's right to make people get vaccinated. There were a bunch of little cases like that all got thrown out. This is the first case that had some real meat to it, and where the analysis is very clear. So I would commend anyone to read this decision to understand when you're dealing with a religious exemption, how it's likely to be interpreted. I think this case will be a template going forward. So this is a nice case. I like this one. And the reason I like this one is the employer got it right. And not only that, it had a crystal ball. So this employer, 5 years before the pandemic, negotiated a collective agreement because it had the foresight. It knew a pandemic was coming. It watched some of those TED Talks from Mr. Gates and just decided, you know what, this is coming. So we need to have a collective agreement that requires employees to inoculate if required by a client. And of course, Paragon Protection Limited is a security guard company, right? So they don't have security guards at their own site, or I guess I suppose they might, but in general, they send them out to client sites. And so if the client has an obligation, if the client in their contract says, don't send us a guard unless they're vaccinated, well, Paragon can't send them a guard who's unvaccinated. Even if the person has a valid exemption under human rights, you can't impose essentially what is trespass on your client. If they say someone who's unvaccinated can't come on my site, that's the end of it. Okay, that's how it is. So the arbitrator says, well, number one, receiving the COVID vaccine is voluntary. That's interesting because this is a mandatory policy. If you don't get vaccinated, you don't get work, and ultimately your employment comes to an end. How can it be voluntary? Well, it's voluntary because you can decide. Do you want the job or not? If you want the job, the condition is get vaccinated. So there's a financial response or result, but that's not the same thing as making it mandatory that you inject yourself. You're not being assaulted. You're not being held down and injected with the vaccine. You're making a choice between alternatives. The company is taking every precaution reasonable in the circumstances pursuant to, as Ryan mentioned before, Section 25(2)H, the general duty clause. So what this arbitrator is saying is we're in the middle of a pandemic, employers aren't sure how to protect their people. And this is one of the available tools to protect them and the public and their customers, other workers in the workplace. So is this a reasonable precaution? The arbitrator said yes. So the vaccination policy was held to be reasonable because it struck an appropriate balance between the affected parties in the workplace, the public, the workers, etc. Okay. That was in November of 2021. Try to keep an eye on the dates of these decisions. I've tried to provide them when I can. So here's a case from January of 2022. This is I don't know how, is that Bung or Bunge? I don't know. Hamilton, Canada. Bungie? Let's do Bungie. That sounds fun. So an employer operates two food oil refining facilities, basically canola. That's what they did. Is their primary business, as I understand it. And they operated on land they had leased from the federal government. So even until very recently, the federal government had higher standards for access to various facilities, rules for its employees than other provincial jurisdictions had. And at the Port of Hamilton, the federal government required that none of these people could come onto the site to do their work unless they were vaccinated. So the arbitrator in this particular case said, well, your policy is your mandatory policy is acceptable because you can't operate your business if your people can't get onto the factory grounds to do the work. So this sort of couples with what happened in the Paragon case. It's a requirement of a third party. And that requirement of a third party prevents you from doing business unless you comply with that requirement of a third party. Okay. And so that's sort of, it's a little bit complicated that way. What if the requirement was, well, we don't want anyone of a certain color or race or age to be sent to work on our property? There might be a bigger issue there, but as their employer, would you be obliged to do something about the fact that they're saying you can't send someone to our property that's not under your control but ours who doesn't meet these criteria? And the case law here says you're not, as the employer of that direct person, responsible to impose a requirement for them to trespass on the property of a third party. That's not a reasonable requirement. And in this case, the vaccination policy was ostensibly upheld because of that distinction. Now, here's an interesting one, and I'll put a pin in this one as I talk about it, because then we're going to refer to the other case that happened just a few months later, as I read you the paragraph at the beginning of the presentation. So this is Electrical Safety Authority. They send out inspectors to go out and look at properties and check permits and ensure that the work is going to be done in accordance with permits and the building code, et cetera. And the employer in this case had adopted initially a vaccinator test policy. And this is when that was the order of the day. The chief medical officers of health were telling people that's the middle ground. That's what you should do. The arbitrators and labor board were all seeming to suggest that, well, there are extremes. This is the middle ground. So let's go with the middle ground because that's probably more reasonable. Kind of cutting the baby in half. I'm not a fan of that from a logical perspective, but I can understand the emotional reasons why people don't like to do the things on the outer edges. They think, well, let's just do what's in the middle. But then this employer pivots, and they pivot to a mandatory vaccination policy. But they didn't have an uptick in the number of people who tested positive. They didn't have an uptick in the number of customers who said, well, you can't have this office inspector on my site unless they've been vaccinated. There were no operational or health in the workplace reasons to suggest that there was something wrong with the vaccinator test policy. So if the vaccinator test policy was working, why isn't that the reasonable precaution? And in this case, the employer didn't mount sufficient evidence to prove that there was a good enough reason to impose a new policy. It wasn't reasonable when the other policy was itself reasonable, is essentially what the decision, it's very long. It's essentially what it boils down to is what was wrong with the last one? You have to prove that there's a good reason. Otherwise, I'm going to find it unreasonable to make it more onerous. Then comes the Power Workers Union against the Lexicon Energy. This was the case where I read that paragraph at the beginning about how context matters, right? And how it's dynamic. And you have to look at the pandemic as a dynamic thing over time and how what was right a month ago might not be right today. So here, the union relies on this decision that was decided in November of 2011, and they argue the same case. And they say, well, you know what? We think that the same thing applies. And these guys had a vaccinator test policy, and they changed it to a mandatory vaccination policy. And that should be the end of the discussion. And the arbitrator said, well, hold on a second. The pandemic has changed. The science has changed. As it stands, the testing is no longer an effective way of detecting the Omicron variant. It's much harder to detect with the rapid tests, or unless you go and do a PCR test, which isn't in use really at this point. And so if the rat test isn't going to do it, then vaccination really is our only effective means of taking some reasonable precautions in advance. And so back when we had Delta, vaccinator test was fine. Now that we have Omicron, well, apparently maybe that's not sufficient because testing isn't going to work, right? So what do we do with this? Well, another case comes along in March. This is the Coca-Cola bottling case. So here are the employees working in a bottling plant, really close together in the facility. And the retailers required that suppliers' employees be vaccinated. So again, we have this third party element. Your employees have to interact with third parties, either at your site or the site of a third party. And as a result, there was more chance of them being exposed. And in fact, this employer was able to mount evidence of an impact on its business directly from the pandemic. So they had partial plant closures, 2 employees had died, 13% had tested positive when the vaccinator test policy was in place. And so having a mandatory policy was found by this arbitrator to be a reasonable precaution in the circumstances that existed at the time that the arbitration was heard. Here, the employees could not work remotely. They're in a factory. The less intrusive means had not kept the workplace safe. So we had tried to do other things, and yet we had people die. We had almost 15% of our workforce get COVID, and the rapid testing was ineffective. And as a result, not only did the arbitrator find that the policy itself was reasonable, but also suggested 4 weeks was appropriate for implementing discipline. So you could give them 4 weeks to sort of rethink. And then after that, if they didn't vaccinate, that would be a sufficient grounds to implement discipline. Though he doesn't expressly say that discipline up to and including termination in those circumstances would be appropriate, but ostensibly that's the end result of discipline, is it not? Maple Leaf Foods, another case, a little bit more recent. So the employer here implements a mandatory vaccination policy, and non-compliant employees are not terminated or disciplined. They're placed on a unpaid leave. I suppose it's a disciplinary unpaid leave. And the arbitrator upholds the policy. Similarly to the Coca-Cola case, these employees work closely. An outbreak had resulted in a plant shutdown, or if it had, I should say, it would have had a significant impact on the food. There's only so many meat processing plants in Ontario. This would have had a significant impact on the food supply to our community and to our exports. And the employer's legal duty, again, back to that general obligation, 25(2)(h), to take every precaution reasonable in the circumstances, was engaged. They had to do something. Was this a reasonable precaution in the circumstances? Here, again, the arbitrator relied on the fact that the rapid antigen testing was no longer seen as an effective method of testing for the dominant variant, which by April of 2022, of course, was Omicron and different variants of Omicron or subvariants of Omicron. TDSB, March of 2022, we have a school board that implements this policy. Now, this is an interesting one because, of course, there is a Vaccination of School Pupils Act. It's sort of this name that sounds like it comes out of an ancient novel. But that permits the school board and the province to require students to have certain vaccinations or they can't attend school. And this has been challenged in multiple different ways, and there are certain exit valves for certain exceptions, but in general, you either get the vaccines or there are consequences, okay? And that has been upheld as consistent with our charter and the Human Rights Code. So why aren't we requiring, once it was shown to be safe, the students that these teachers have to work in close proximity to vaccinate? I think that was more of a political decision than a scientific decision. And I think it was one of the reasons why I was a little bit surprised at the decision in this case, which essentially held that having a policy that non-compliant teachers or other staff who were in the school would be in close proximity to school children who could be quote unquote vulnerable. And I'm not sure why the people who are least likely to get the worst symptoms and die from a disease, as opposed to the workers themselves, are the vulnerable population we're talking about. But in any event, vulnerable school children had to be protected from the big bad virus, and the employees were the vector bringing COVID in and spreading it, and they all had to get vaccinated or else they'd be off on leave. Again, I'm not sure why we didn't have a rule that said that students also had to get vaccinated. A number of colleges and public universities put that in place. I think it really is just a question of what's palatable to parents. Once vaccines arrived, this is from the arbitrator, and were determined safe and effective, the paradigm shifted. It would be derelict to ignore the vaccines and the benefit of full vaccination and pretend they were not a real game changer. The precautionary principle requires that employers like the TDSB do whatever they reasonably can. So I like these sentiments. I'm not sure that I think that this might be all precautions reasonable in the circumstances, but is it among the tools in the tool chest of the employer? I think it was. And so I understand the reasons for the decision. I'm not sure the policy goes far enough from a safety perspective. Harmar and Tribe Management, it's from the last cases I'll mention here. This was the first civil case to deal with this issue out in BC in September. And this is a property management company where you have folks who are going out to properties with, populations of people, show them things and manage the actual properties of these condos. And the employee refused to vaccinate, any employee who refused to vaccinate was placed on an unpaid leave. They weren't fired, they were just placed on a leave until the rule changed or the policy changed. Court found the policy was reasonable when the employee challenged this as a form of constructive dismissal. So unless you have a right, as Jeff mentioned in respect of IDEL, unless you have a right to lay me off, laying me off or putting me on a leave without my permission, that might be constructive dismissal. And so in this particular case, the court said, no, we have the right as the employer to take precautions reasonable in the circumstances, to require you to attend at work fit for duty. And this fit for duty policy said you had to be vaccinated. And if you weren't, it wasn't safe to have you in the workplace. So it was appropriate to put you on an unpaid leave and not terminate your employment. So again, we have this echoing of that first case I talked about, where the court here, not an arbitrator, but the court says, we're not mandating that you stick this foreign substance in your body. We're giving you a choice. It's still voluntary. You can choose to vaccinate or you can choose not to vaccinate. And if you don't, then you're not going to earn your income. But that is still a choice. And that's sufficient for legal purposes. How much time do I have left, Landon? Ish. Okay. So the future of COVID vaccination policies, what may be reasonable is an evolving question. You have to keep an eye on the status of the science, the status of the local regulations. What is your local public health unit recommending? If you're going above and beyond the local public health unit's recommendations, you should have a reason. You're not going to be held to a standard of perfection. Early on in the pandemic, the government in Ontario issued legislation which protects companies which take precautions that are reasonable, which aren't acting recklessly, and which follow local guidance in accordance with the law, from being sued when someone gets COVID. Okay, so if you don't go far enough, but you go as far as it seems reasonable to do in the circumstances and you comply with the law, you shouldn't be successfully sued, I guess I should say. Is it possible someone could sue you? Sure. I haven't heard of any successful civil lawsuits for people who got COVID, not talking about what might happen in the long-term care sector. That's entirely different. Changes in legislation and public health will inform what is reasonable, so you have to keep an eye on that. Consider the specific workplace. Do you have people working in close proximity to each other, to members of the public? Are they going to other jurisdictions where there are different COVID rules that may have an impact on whether or not they're being kept safe? Mandatory leave policy is more likely to survive than suspension and termination. Again, it's an unpaid leave policy, and ultimately you may end up terminating people, and you may just have to sort of be the next test case on whether that termination is the appropriate response for failing to meet your policy. But you'll have to decide what's right for you and what the best thing is to do to help keep you and your workers safe. So those are my comments.
Thank you, Jeremy. It's Q&A time. Do we have any questions live? So no. Okay. We have a few online. Okay. First of all, what happens if the employee is immunocompromised and on immune therapy and their doctor has recommended their absence until vaccines were available?
Okay. Well, so the Human Rights Code requires us, when we have an employee with a valid medical exemption, to give them an exemption from the requirement that they get vaccinated. But it doesn't require us to make work that isn't productive. It doesn't require us to permit necessarily remote work if we don't have the capacity, or it won't be productive, or it's not conducive to our operating model. But if you've been doing remote work for the last 2 years and you have a COVID must vaccinate policy and someone says, I'm immunocompromised, I can't take this drug and simultaneously get the vaccine, I'd like to continue working from home while this vaccination policy is in place, that might be a reasonable precaution in the circumstances. And it may be difficult for you to show that you were able to endure the hardship of having your entire workforce working remote, but for some reason, this one person who needs this accommodation because of a bona fide medical condition can't still work remotely. If working remotely isn't even possible because of the nature of the work, you aren't required to make work for them, but you might be required to look at other work that would be productive that they could do on a temporary basis, not as a job, but as sort of a set of duties on a temporary basis as a form of accommodation. I'm not sure that allowing them to come into the workplace and having everybody in hermetically sealed units would be a practical answer. So you probably can't bring someone who's that vulnerable into the workplace if they have a valid concern. I think that would be an undue hardship to have to go through that level of PPE, et cetera, to bring them back, but you might be required to let them work remotely.
Okay. Can employers fire employees who refuse to get vaccinated?
Well, that's the million-dollar question, right? And the answer is maybe. So step one is, are you unionized or not? If you're not unionized, it's a simpler question, but it's still worth at least $750,000, okay? So what you're dealing with is your policy reasonable? Do you have exit valves for people with valid human rights objections? Is there anything in your contract that would in some way prohibit you from asking for this? Is there anything in your contract that would somehow allow you to ask for this? If we think about the drug testing cases, one of the reasons why the TTC's random drug testing policy survived initial scrutiny is that they had pre-employment drug testing. We think about the Paragon case with the security guards. They had already agreed in their contract that if our clients require us to get vaccinated, we agree that we can be required to be vaccinated, or that assignment isn't for us. So I think you have to look at all of those things. Ultimately, if your policy is reasonable, if it's implemented in compliance with the human rights law, and it's within the reasonable scope of an employer's ability to promulgate policies for health and safety reasons, as we've heard, putting someone on an unpaid leave of absence for a period of time, and then after that, if the pandemic is still raging and you need to hire someone else for their position and don't want to hold their job out, yeah, I think at that point, as long as you've warned them sufficiently that if they don't come back or get vaccinated by a certain date, that their job will come to an end, yeah, I think at that point you can fire them. Will you get sued? Probably. Will those cases, if they've been happening, settle? Probably they all have at this point. But there will be an employer who gets hit with that exact case. We had the constructive dismissal case we looked at from September of this year, which said an employer in that circumstance was not constructively dismissing. Ultimately, that person would have been terminated had they not just quit and said, I was constructively dismissed. So I think the answer is yes, maybe.
Can our vaccination policy be considered harassment or discriminatory against those who are refusing vaccinations?
Okay, can you read that again?
Can our vaccination policy be considered harassment or discriminatory against those who are refusing vaccinations?
Okay, so let's deal with the easy one first. Discrimination, right? So discrimination is what the Human Rights Code says it is. And if it's not one of the enumerated grounds, it's not discrimination. And that's the end of that. Harassment, which is civil harassment, not based on a ground under the code, that can happen for any number of reasons. My employer was mean to me. The supervisor keeps asking me to do my job. The manager says I have to follow this policy that says vaccinate or I can't come to work. These are all things that people like to complain about. If your policy is reasonable and you apply it consistently, and it's not an unlawful policy, it's probably not harassment to implement a policy that you're taking for reasonable precautions in accordance with your obligations under health and safety law. That's the end of that. If you implement it in a way that is harassing, you single somebody out, you're unprofessional in the way in which you roll it out or treat individuals who decline, that might be harassing. But the mere act of promulgating and implementing and enforcing a policy, no.
Okay, we've got 2 more minutes. So
2 minutes.
I'm going to ask for quick answers, real quick answers. Julie,
Yes.
which I know is not hard to do. Legal issues, right? This is a good one. Follow up on the discrimination question. What if the employee refuses to be vaxxed based on their quote creed unquote, as it goes against their worldview and the way they live their life?
Okay, so that sounds like we have a duty to inquire as to the basis for their belief. We would in that case, my advice would probably be get the employee to put in writing in as much detail as possible what it is that their deeply held belief and way of living and way they see the world is, and in what way that having a vaccine would be counter to that way of living. I think at the end of the day, the answer is no, that's not a valid objection. But at a minimum, you have to go through the process. And if you get an answer that changes your view, you have to be open to changing your perspective.
Just the one thing I would add to that answer, the Ontario Human Rights Commission actually came out with a policy about this stuff. And they said creed is not actually, like, someone can't say because I happen to be against vaccinations, that doesn't count as a quote creed, quote unquote, under the Ontario Human Rights Code. So
it was the first part of the question that I think you had to inquire more deeply into.
Okay. What do you anticipate the outcome will be for employees who have been terminated because they weren't vaccinated, but now the company's mandatory vaccination policy has been rescinded?
Well, one option, if you get a demand letter and it hasn't been all that long, and if they weren't singled out or made to feel personally like a bad person, would be to say, hey, we could have not terminated you. I suppose you could have just been on an unpaid leave. How about we bring you back now that the policy isn't in place anymore, to the same job and in the same position at the same compensation. Employee says, no, I feel really bad about the way I was treated. Now you have a mitigation argument. I suppose that might be one option. If it's been really long or you really just don't like this person, well, then they will, you don't want to bring them back as an employee. They're a troublemaker and didn't follow your policies. You don't have any legal obligation once their employment ends to bring them back, unless when you let them go, it was a violation of the Human Rights Code. So that would be sort of the rough version of that answer.
All right, thank you, Jeremy. I do know we had one live question here, but if this is the person that's here live, she can get Jeremy.
I'll take it with me and
break.
I'll answer on the break.
There you go.
Thank you.
Our next speaker is our associate Hadi Malik. And Hadi is going to be discussing workplace change in the law of constructive dismissal. And Hadi recently worked with me on a constructive dismissal case that went to court, and we recently received the decision on. So he's speaking from some real life litigation experience on this one.
I will be talking about that decision, by the way.
Be careful what you say about it, right?
Parse my words. Hello, everybody. I'm Hadi. I'm the associate at Stringer, in case you haven't heard. Today, I will be talking about the elusive topic of constructive dismissal. As you all know, the employment relationship can come to an end through various ways. You can obviously terminate the employee for a cause, without cause. The employee can abandon their job. In rare cases, frustration can occur, or it can be the simple case of a fixed term contract coming to an end. Then there's the issue of constructive dismissal, which applies to non-union environments. So what is a constructive dismissal? A constructive dismissal has various parts, and I'm going to say this for you again and again because it's a lot of words. So constructive dismissal occurs when an employer makes a unilateral and substantial change to a fundamental term or condition of employment, and the employee does not agree with this, does not acquiesce to this, and in most cases, the employee will resign and claim that they're constructively dismissed. And it's sort of in the word, if you think back to it. The employer has constructed my dismissal, is what the employee is saying. Though in actuality, they quit the job. So there's two main responses an employee can have to a constructive dismissal. Like the first one I said is obviously resign and then sue for damages, or the other is to accept or acquiesce to the change. So when the employee says, okay, you've made a fundamental change to my employment contract, but I'm okay with it, or the employee says nothing and then decides to make a stink of it 6 months later or 8 months later, that can be to the benefit of the employer later on. So there's a two-part legal test to a constructive dismissal when we're asking, well, what amounts to a constructive dismissal? So before I get to examples of things that can amount to a constructive dismissal, I'll run through the test with you guys first. The first question we ask is, did the employer unilaterally make a change to the employment contract, something that went to the heart, to the core of the employment contract? If the employer has a contractual right, whether that's expressed or implied to do it, there's no constructive dismissal. Or if the employee consent or acquiesce, then there's likely no constructive dismissal either. Then we move on to the second stage, and we ask, would a reasonable person in the same circumstances as the employee think that they were constructively dismissed by this action? If yes, then the employee is constructively dismissed. All right, now to get to some fun examples, and one of these is the case that I did with Landon. So constructive dismissal is unfortunately a very amorphous concept, and a lot of things can amount to a constructive dismissal. A first example, the one we dealt with kind of recently, is a significant reduction in compensation. So this is likely more than 10 to 14% of total compensation. The recent case Landon and I had was where an employee had his company truck taken away that he had for his both personal and business use for a long period of time, and the court in our decision found that that did indeed amount to a constructive dismissal. But also a temporary layoff can amount to a constructive dismissal where the employer doesn't have an express or implied right to lay off the employee. So this is why we often recommend, if you're in a business where there's going to be a lot of annual temporary layoffs, it's a really good idea to just build it into the contract, your right to do so. Another thing that can amount to a constructive dismissal, and this word is so hard to say every single time, is a demotion, elimination of the position or transfer, significant change in job duties, or change in reporting structure. So there are situations sometimes where, let's say all of a sudden your subordinate becomes a person you're reporting to. There's an argument to be made that that changed a fundamental term of the employment contract so as to amount to a dismissal. Also, something that can amount to a constructive dismissal is workplace harassment and bullying. Now, this one's kind of tricky. It really depends on the circumstances, and it sort of occurs where there's a pattern of workplace harassment and bullying, so much so that it creates a poison work environment. And normally it's a constructive dismissal where the employer condones it or sort of does nothing significant to address it. So much so that an employee feels that a fundamental term of their contract has been breached, they can no longer work there, it's untenable, and they've effectively been dismissed. Other than these, one really interesting case study of it sort of shows sort of the wide range of employer actions that can amount to constructive dismissal, is this Felice decision out of the Ontario Court of Appeal a few years back. So this case involved a shift security supervisor at a casino. In and around 2007, the OPP informed the employer that they were investigating this guy for theft in the workplace. So he was placed on an investigative suspension while the criminal investigation was undergoing. A few months later in 2008, the charges were dropped. So he was charged and the charges were subsequently dropped. And the Alcohol and Gaming Commission also suspended his gaming registration. So once the charges were dropped, the gaming registration suspension remained in place. The employee decided not to appeal it. As a result, the employer terminated the employee, citing frustration of contract because they said it was essential for him. Well, it was essential for him to do his job that he had this gaming registration license. The employer also refused to pay him for the period of the administrative suspension, and they relied on the terms of the employee handbook, which I'll read out to you. So it said, investigative suspension may be used as part of the coaching and counseling process to verify allegations of misconduct. During an investigation, the associate or the employee may be prohibited from working. If a decision is made to separate the associate's employment, he or she may not be reimbursed for the time spent on investigative suspension. So the employee sued for constructive dismissal. This eventually made its way up to the Court of Appeal, and the court found that the suspension without pay, even though it was allowed for in the employer handbook, was unreasonable in the circumstances and therefore did amount to a constructive dismissal. This was because they didn't have any proof of misconduct, and it's a very high bar to suspend an employee pending investigation without pay, without having some sort of reasonable grounds to back it up. The court found that this was indeed a breach of the fundamental breach of the employment contract, and the employee got damages as expected. So this case is rather unconventional relative to the more common cases of constructive dismissal that comes up, because it really turned on the facts. And in this case, there was an employer policy which specifically allowed for not paying for the time on investigative suspension. And it's a big reminder that employers still have to consider reasonableness in executing their policies. So earlier I mentioned the concept of acquiescence. So if an employee acquiesces to the fundamental change made by the employer, there's no constructive dismissal. Often when we get lawsuits from employees for constructive dismissal and we believe there's been an acquiescence, that's often our defense. So an acquiescence is defined as an inference that can be made of permission or consent arising when a person raises no objection to or takes no action or infringement over a legal right by another. So let's say an employer engages in a temporary layoff, lays you off, and they don't have a contractual right to lay off. At law, that's a constructive dismissal. But let's say you decide to wait 8 to 12 months to say anything about it or to allege that you've been constructively dismissed. Is there an argument that you've acquiesced? Probably. So how long is too long to acquiesce? The case law is pretty varied here. I'll run through some of the cases I'm citing. So in the Lancia decision, our 13th month delay in bringing a claim after resigning was found to be too long. In the Kirk decision, the motions judge found that 6 months was a sufficient amount of time, though the decision was overturned on appeal for different reasons, and also commented that 2 years would be too long. However, in another case, it's called McGinty, a 2-year delay from leaving work due to a mental condition was found not to be too long, since the delay was based on the same issue as the absence and the employee had anxiety and depression. So as a general barometer, I'd like to say that perhaps around 6 months should be sufficient for an employee to decide to challenge or not, but again, it'll be very fact specific. Right. So constructive dismissal and COVID-19. I have various topics I'd like to talk about. I'm sure many of you have dealt with them again and again, but we'll start with vaccination policies. Jeremy's touched on that just a little bit. So as of August of 21, employers in Ontario were required by law to follow the advice, recommendations, and instructions of the provincial medical officer of health. Mind you, this doesn't say the word orders, it says advice, recommendations, and instructions. What recommendation was made at the time, I guess subsequently after this was issued, was that every employer should have a vaccination policy in place for COVID-19. So many employers did institute these policies as a response. I'm sure many of you did as well. And there were consequences instituted for non-compliance in some cases, depending on the workplace. Some employers had the option of terminating, and some actually did choose to terminate employees for refusal to comply. Whether or not this amounts to cause for termination hasn't been decided by the courts yet, and I'm not sure if that case will come up. And obviously these policies should have been and should be subject to human rights considerations. So with respect to these policies, many employers decided not to go to the termination route and sort of wait the pandemic out and see how things went, and it has evolved. So many of them kept the option of when rapid tests were available, and sometimes they weren't, of making the employees do daily rapid tests at their own expense if they were going to come in person, or put employees on unpaid leaves of absence if they were not going to comply with the vaccination policy without a valid human rights exemption. And in these cases, the question comes up, well, does placing an employee on an unpaid leave of absence for failing to comply with the vaccination policy amount to a constructive dismissal? Up until very recently, there were no cases deciding this. And I will shortly talk about one that came up and was very good for employers. Before I get to that, I do want to note that a leave of absence doesn't really solve the underlying question for many workplaces. So if you're going to maintain the posture that it's vaccinate or bust, eventually you'll have to decide what to do with that employee. And especially in unionized workplaces, this can be challenging, where you have to consider, well, do I leave this employee on an indefinite leave of absence? And if we're considering terminating this employee, what are the steps we can take to best insulate ourselves from a civil claim in the union context or a non-civil claim. A civil claim in the non-union context or grievance in the unionized context. And these are very, very challenging things sometimes and can be fact specific. And I suspect would require a significant amount of, or at least a sufficient amount of notice being given to employee that if they do not comply, they will likely be subject to termination. So this lovely case that just came out of BC, Parmer, which Jeremy touched on a little bit. So the employee here was placed on an unpaid leave of absence for failing to comply with the employer's vaccination policy. This was the very first civil case to hear whether non-compliance with the policy equals a constructive dismissal. And I won't bury the lead here. The court said, no, it does not. So here are some of the key factors that were present. The employee's leave at that time was for a period of 3 months, was subject to review. They didn't replace her. She was asked to return some employer property, but she continued to receive benefits. And the employer did not intend to terminate her employment. She was expected to fulfill a new role and was a valued employee. So ultimately, in deciding in favor of the employer, the BC court said this. The assessment of the reasonableness of the employer's mandatory vaccination policy must be considered based on the state of knowledge about COVID-19 at the time it was implemented. Approaches to managing the pandemic have evolved as more information becomes available and as the effectiveness of vaccines become known. So this was a very important point made by the judge because the judge just sort of recognized that the pandemic has been evolving and what's reasonable at one time is not necessarily reasonable at another. So the vaccine policy should be seen at the context at the time it was implemented and applied and not at any other time. So the judge concluded that the policy was reasonable based on two main points. The first of which was that COVID has obviously brought extraordinary health challenges for everybody. And second, the employee wasn't forced to vaccinate. There was no unreasonable breach of the employee's sort of inherent rights against, being forced to take medical treatment. The choice was between vaccination and continuing to have income, or not, and non-vaccination and losing the income. And that was a choice that was made by the employee of the employee's own free will. So, constructive dismissal and returning to the office. So many of us, pandemic hit, went to remote work models, either hybrid or full remote work. Some employers may not necessarily have been explicit to employees that this is only temporary, though it's understandable that given the inherent nature of the pandemic, this was something that was understood by everybody, that eventually we were going back to either a hybrid model or being back in office permanently. Now we're in a situation where a lot of employers are in a hybrid. There may be some employees who prefer to work from home, either due to childcare considerations, not liking their commute, or maybe they even moved away from being close to the workplace to somewhere further away. Some may argue that terms and conditions of employment relative to their work location change permanently, and this may lead to a constructive dismissal claim. So what's the result of all of this, of bringing employees back who were initially full-time in office, then became remote or partially remote during the pandemic, and now you want them to return? It's improbable that temporary measures, such as those that were legally mandated or strongly recommended by public health measures, are a permanent change to the employment contract that can result in a constructive dismissal. However, let's say you hired an employee on during the pandemic and they were hired on either as fully remote or as a hybrid worker, and they've never worked in office. And it was never made clear to them that, this is sort of a temporary arrangement and they will be either returned to they will be brought into a hybrid model pending return to full-time office work, or they'll be brought in full-time depending on the needs of the business as the pandemic changes. Then there may be an argument for constructive dismissal depending on the facts. This sort of happened in a pre-pandemic case regarding remote work. So the Hagholm case, the employee was permitted to work from home 3 days a week for about 20 years. And then the business was sold and the new owner required the employee to return to the office. This was found by the court to be a constructive dismissal. So for this reason, we recommend that if you are bringing employees back, in your communications, you should sort of make it clear that, and if your intention is to return them to the office full-time eventually, that this is the goal you're working towards. And then the gradual phase-in, if you're going to do it that way, will be sort of at least informed by public health considerations at the time. Again, if employees decline to return to work, there may be the option of terminating based on insubordination or abandonment, particularly if they chose to move away during the pandemic. But you have to be careful here, because if you approve the move, the court may hold that you agree to change the location of the workplace, and changing it back would maybe a fundamental breach of the employment contract. I had a client recently who told me that they agreed to let an employee move to the UK to work remotely, and there were some family status issues there as well, but I had to advise that this may be a constructive dismissal issue, because you sort of agreed to this arrangement and not made clear to the employee that this is only temporary. So my recommendation is that if you're going to return to the office, make it a short phase-in period and sort of make very clear what your expectations are, and make clear that you reserve the right, and if you are allowing remote work moving forward on a hybrid basis, make clear that you reserve the right to return employees to work full-time at your discretion as the employer, subject to, of course, human rights considerations. Otherwise, you may be subject to a constructive dismissal claim, but don't worry, we are here. So what are the damages for a constructive dismissal in court? So constructive dismissal is basically the same damages as a wrongful dismissal claim if you terminate an employee without cause. So an employee would claim damages for common law reasonable notice, that is reasonable notice of termination, that's outside of their statutory entitlement. So how do you respond to this? If you have an employment contract with an enforceable termination clause, you would use it the same way as you would in responding to a wrongful dismissal claim or where the employee is terminated without cause. So you would rely on the clause and say, well, this clause, it limits your entitlements to either the Employment Standards Act or whatever is in the clause. If employees have been laid off, you should make clear to them that the recall offer should be or you would like them to accept the recall offer. If they do not, and there's no issue of them being humiliated in the workplace, or there's no issue of them otherwise returning, it could be seen as a failure to mitigate, and mitigation always reduces damages for wrongful dismissal. Normally, punitive damages aren't awarded with respect to constructive dismissal claims, unless there's actual evidence of bad faith or wrongful conduct by the employer, which in most cases doesn't happen. First things first, review your employment contracts. Having an enforceable termination clause can significantly reduce the amount you may have to pay out at termination. And also consider writing terms into your employment contract that allow for certain fundamental changes. The most notable being, and this comes up often, is having an express right to lay off employees if you're in the type of business that may engage in regular temporary layoffs. And this may be a concern. Another thing is just to, a lot of these things can be done by, are resolved at an early stage by just managing employees, listen to the concerns, respond to them, keep a written record of communication, and particularly with respect to workplace harassment situations, where it's always good to build a strong record if you receive a constructive dismissal claim, that the company responded to the allegations, investigated them properly, and let everybody know of the results, and sort of did its due diligence. And that acts as a strong defense for the employer in the event of a claim. If you're going to make other fundamental changes to the workplace, give as much notice as possible if you can. And if you have a constructive dismissal claim, or if the employees allege constructive dismissal based on any of the things that I've mentioned or anything else, or they've already filed the claim, considering reoffering employment. And this is something that we actually dealt with, in our case, Landon and I, where unfortunately, due to the timing, our offer of reemployment was not, or the employee rejecting our offer of reemployment was found to not be a failure to mitigate, but in most cases it is, and it reduces the damages accordingly. All right.
Thanks, Hadi.
Thank you, everybody.
And actually, I'll just add to that point on mitigation. The one issue we did win on in that case, and it wasn't a total loss, Hadi. It was actually pretty good in the end, was the employee after they left. Like the facts were, the company was taking away his truck, and he quickly decided to set up a fishing guiding business. He had a website ready to go, bought himself a new truck actually, to be a fishing guide, which was probably a kind of a cool career change. But then he also moved away from Oshawa. He had two places. He had a place in Oshawa and like a vacation place up in Omami. And rather than stay in Oshawa, which is obviously close to the GTA and close to the jobs, and he had a background as an HVAC technician, rather than do that, he decided to sell the house in Oshawa and move up to Omami. And this was back when the real estate market was vibrant, and he sold his house like the day after listing it, kind of deal. And just before the employer had offered to bring him back to his old job for what might have been a common law notice period. So what the judge said was it was not reasonable for him to move away from Oshawa and the GTA where there would have been more jobs. And so as a result of that, the judge reduced the notice period award quite significantly that the employee was going to receive. So it just goes to show you with these constructive dismissal cases, there's a lot going on usually beyond just there's this change. Mitigation can enter into it, as Hadi was talking about. And just because you've received that legal demand letter or the employee's walked out the door, it's not necessarily over. You could maybe offer them their job back and cut your losses that way. Okay, so now we will get into some Q&A. All right, would it be considered constructive dismissal if someone had a compressed work week, Fridays off for many years, but with hours changed due to the pandemic and staff in the office only every other day, we're now asking them to work Monday to Friday, 9 to 5. Is that a constructive dismissal? So I guess basically they don't get Fridays off anymore. They have to work Monday to Friday.
Could be if the employee makes a claim. A great way of sort of hedging that risk is give them a significant amount of notice that in like 2 months, whatever, we'll put you on this new schedule. And that sort of upends any damages. And also when the employee is given actual notice of these type of changes, they're less likely to get litigious. They know in advance anyways. I guess there's also an argument that this may not necessarily be fundamental to his employment contract, but I guess that's for the lawyers to make.
What if an employer has gone to remote working, but doesn't know if they will ever want to need their employees back in the office full time? The messaging all along has been there's an intention to be hybrid moving forward unless the needs of the business dictate otherwise. Is this enough? So I guess the question is really about like, what happens if we decide to change things in terms of working from the office and working remotely?
So I would say you make it explicitly clear in your messaging that based on the needs of business and the status of the pandemic at the time, until further notice, you'll be on a hybrid work model. However, as the company, you do reserve the right to bring the employees back to office full time at your discretion. And throw that line in there at the end and it can be saving.
Now, what's our liability if the employee is claiming constructive dismissal, but they have a valid ESA only termination clause?
So the employee will get a lawyer and the lawyer will likely say the clause is not enforceable. And that's something that Landon and I would argue that yes, it is enforceable. If the clause is enforced in court, then the employee's entitlements, at least to notice, are limited to whatever is in the clause, whether that's just their ESA entitlements. However, if the employee claims punitive damages or other damages and there's some meat behind those claims, those could be awarded by the court separately.
And that's another good reason to have an ESA only termination clause or termination clause in your contracts. Because then if you do have a constructive dismissal scenario, your exposure to liability is significantly reduced compared to if they didn't have the termination clause. The employer wants to change the employee's workspace to 50 kilometers further than the original contract. Is this a constructive dismissal?
Could be. Yeah, depending on the facts, could be. Again, these things, if you need to do them, give the employee notice as much as possible.
Right. Now, the case law is really variable in terms of increased distance for commuting, and a lot depends on personal circumstances for the employee. I can think of one case where an employee was single, no dependents, and the company wanted to transfer him to BC from Ontario. And the employee refused, and the court said, well, that wasn't a constructive dismissal. You should have taken that job and moved to BC because, you're a single guy and no problem, right? And then there are others where an employee is transferred like from Mississauga to the other side of the GTA, and that's considered a constructive dismissal.
Driving on the 401.
Yeah. So really depends. And 50 kilometers could depend. Are we talking 50 kilometers like up north, driving on an open highway like Highway 11 or something? May not be that big of a deal, but 50 kilometers across the GTA, well, that is a big deal in terms of commute.
Is that all?
Here's one. What if we have decided to take away an employee's discretionary bonus, and the bonus just depends, on how the company's done year to year?
So taking away a discretionary bonus may not amount to a constructive dismissal as long as you made clear that it's absolutely discretionary. The word discretion in there really saves you, and if you've applied it like it's discretionary as well, then you should be okay.
Right. The only thing I would add to that is, let's say if that quote discretionary bonus, it's, I'd say, in an unwritten plan, but every year the employee receives $5,000, right? That's just something they've always received. Then if you say, okay, that's going away now, depending on how much it is, it may or may not be a constructive dismissal. If that $5,000, if the employee is making $100,000 a year, that's probably not a constructive dismissal. If that employee is making $25,000 a year, then it might be. So it depends. All right. So we've got a few extra minutes to play with, which is good because we have a really exciting announcement to make at the end of the break. So don't go away. We're going to resume at maybe a bit earlier, where we're supposed to resume. Well, actually, it was. Yeah, so we'll resume a few minutes before 3 o'clock. We have in the schedule. And then nobody complains if we wrap up a little bit earlier at the end of the day. So we'll come back at 2:55, so that we have a few minutes for this really exciting announcement. And then we'll follow that at 3 o'clock with our legal roundup.
Thank you.
Welcome back. Okay, so now it's time for this mystery announcement that I've been talking about. And so the big news is we have a brand new website that we are launching live. And this thing's been 2 years in the making, if you can believe it. I won't get into all the reasons why it's taken so long, but anyway, 2 years in the making. So we're going to launch it, and Jeremy's going to give a little bit of a tour of the website.
A little drum roll, please. And hopefully it works. Hey! Okay. Okay. So this is our new, this is,
And that's us rowing,
yeah,
because we're a rowing team as long
yeah,
as well as being a
I'm the
law
one on
firm.
the left there. Okay,
Right.
so it's our new fancy website. We've got all the fancy technology. It no longer looks like it was built in 2011, which is when the last one was built. And it's got all the fancy buttons and things move in a nice way. And it appears to work. Also on mobile devices. We do have still the same content. So if you're out here, we've got a tab for COVID-19. Unfortunately, as long as that remains a thing, it will remain a little tab up at the top that takes you to all the resources and webcasts and replays of programs and updates that we've done over time. And then we've got our team with the pretty pictures. Some of us even got some new ones done, which makes us all look nice. And we've got our new address there at 20 Queen Street West, which is where we moved in the middle of the pandemic, worrying that we weren't actually going to be allowed to have people come and help us move, but it worked out. So that was nice. And if you're looking for our seminars and events, they can be found under resources. So next time you're looking for this, that's where that will be. And once the webcast of this, the recording of this webcast is ready, we will put a probably one session at a time, the ability to rewatch what you've gone through. So that'll be great. Looking forward to everybody telling me about the experiences that they've had and how it's all broken and not working. So please do let us know if you experience any issues. There are some improvements that are still yet to come that weren't quite working. And so we've taken them off for now. But otherwise, we're proud of this. And hopefully it makes us look like we're a 2022 law firm, not a 2011 law firm. So.
And if you go under resources, can you click
Sure.
on resources? So under resources, we have our updates. Are all our updates on there?
Should be.
Okay, so we have fair history on our updates with different categories by subject matter. And then we also have our HR blog. And if you're wondering what the difference is, our updates are a bit more detailed, bulletins on legal developments, whereas our HR blog tends to focus on more practical matters, but maybe not as significant legally, but nonetheless things you might be want to be aware of as an HR professional.
And if you want to just randomly search through all blogs, updates, and media content, but not the entire site randomly, if you just click on resources, there's a search field and it'll allow you to sort of look for the content that we've produced over time. So we've tried to stay on the cutting edge of these things, although during the pandemic, there were sort of starts and stops in terms of how much new stuff was coming out. We're probably overdue for our next big update. We'll get one going after our conference is done.
And if you don't currently receive our updates, if you click on the subscribe button, then you will receive our updates, which includes not only our legal updates, but also announcements for webinars and our annual conference and things like that, learning opportunities. Okay. Great. Well, then I will launch into our legal roundup portion of our program. We have 4 topics that we'll be covering. And I'm starting off with the status of the constitutional challenge to Bill 124, otherwise known by its political title of Protecting a Sustainable Public Sector for Future Generations Act 2019. So this piece of legislation is being challenged by over 40 unions in court. And they're asking the courts to declare this act to be void because it violates the Charter of Rights. And the arguments have been made in the Ontario Superior Court of Justice. That's where the case is right now. They were made in September. We're waiting on the decision. Now, I don't expect this will be the final word, whatever the decision is. There will no doubt be an appeal. Regardless of the outcome, you can almost count on there being an appeal to the Ontario Court of Appeal, and then most likely this ends up in the Supreme Court of Canada. So that might take another couple of years before we have a final word on this a very important piece of legislation. Now, you might think, well, why is it important? Maybe you're not a unionized employer. Maybe you're not subject to Bill 124. And so you might think, oh, this doesn't really matter to me. Well, actually, according to if you live in Ontario and pay taxes in Ontario, it might matter to you, because according to the Financial Accountability Office of Ontario, it's on a report and estimates that a court defeat on this case could cost the government $8.4 billion between 22 and 23 up to 26, 27. So $8.4 billion, that's a lot of money. We might be paying some extra taxes if this court challenge succeeds. So first of all, just maybe a little bit of background on Bill 124 for those of you who haven't had the pleasure of being subjected to it. It was introduced in 2019. It applies to Crown agencies, universities, hospitals, long-term care homes, organizations with boards primarily appointed by the government or receiving more than $1 million of government funding. This legislation does not take away the right to strike, so you could still have a strike with it. But what it does do is it imposes a 1% cap on salary and compensation increases for both unionized and non-unionized employees, subject to certain exceptions, such as if the employee were to complete a training program and under a compensation plan, then gets bumped up to a higher level within the organization. And the legislation doesn't go on forever, but it has, for every organization, there's a 3-year moderation period. So once you start on the moderation period, you are subject to this for 3 years, at which time it ends. So one thing to know about this court challenge is it's being brought under Section 2D of the Charter, which is embedded in our Constitution. And Section 2D preserves freedom of association. There is no mention of collective bargaining in the Charter. There's no mention of the right to strike. This is a right that the Supreme Court has interpreted as being inherent to the freedom of association. And this is like, as you know, you might be aware, has come up recently with the Ontario government's use of the notwithstanding clause today, actually, in respect of CUPE and the government and the education workers who were, will, may or may not be striking tomorrow. So the reason the government has invoked the notwithstanding clause, which basically is the out for a government to say, like, the Charter doesn't apply, the Constitution doesn't apply to this legislation, is because under the Supreme Court's case law, if they didn't have that in there, odds are the courts would have said that your legislation taking away their right to strike would have been contrary to the Charter. So that's why Doug Ford and the government have made that move to put it into the legislation. And we'll see what happens tomorrow, right? So we'll stay tuned on that, especially for those of us with kids who might be affected. So getting back to the Supreme Court and where this right to strike comes from and what it means. So as I said, it's embedded in the freedom of association. And the court has said, here are just some basically sound bites from the various cases handed down by the court. They've said the freedom of association is not merely a bundle of individual rights, but collective rights that adhere to an association. They also say that it is at the heart of that freedom to organize collectively and bargain collectively is at the heart of freedom of association. The court has said a meaningful process of collective bargaining also requires the ability of employees to participate in their collective withdrawal of services, which is a strike, where good faith negotiations break down. And in determining whether the right to a process of collective bargaining has been infringed, the courts must assess whether the measure disrupts the balance of power between employees and employers necessary for the, quote, meaningful pursuit of workplace goals so as to, quote, substantially interfere, unquote, with meaningful collective bargaining. The analysis is contextual and varies with the industry, culture, and workplace in question. So, as you may gather from all of that, the test is clear as mud. Really, the courts have very broad discretion in terms of where they will find this inherent freedom of association to be violated. So, getting back to Bill 124, as I said, it didn't take away the right to strike, but it limits and has limited how much of a wage increase employees could receive. Now, the arguments made by the unions include that the bill is discriminatory in its effect, that 79% of the employees covered by Bill 124 are women, and that the government has an obligation to consider whether its laws have a disproportionate effect on women, and that it has had that the evidence is that it's had a overwhelming impact disproportionately to low wage and low income workers. The Ontario Nurses Association has argued that Bill 124 has resulted in a shortage of workers in the healthcare system. And then they've argued that the fact Bill 124 does not take away the right to strike doesn't save it, because what is going on here by capping the increases to 1% is the government has taken away the right of employees to engage in meaningful bargaining. And so a strike is essentially meaningless and hugely costly for the membership. The government on its side has pointed to the fact that the legislation does not take away the right to strike, to say, look, we can still collectively bargain. It's time limited. It only institutes a cap on wages and compensation, and it doesn't take away the right to bargain other terms and conditions of employment that would ordinarily be bargained. So just on the money. It applies broadly without singling out any one particular sector. It doesn't replace existing bargaining structures, which in the past, that's where governments have gotten into trouble. It's where they've swept aside existing bargaining structures, like by implementing mandatory arbitration. And the overarching goal of Bill 124 is to protect the sustainability of Ontario's finances. And this is a valid balancing act that the government is engaged in. So I think at the end of the day, the courts, what this really comes down to is whether or not the Bill 124 has taken away a meaningful collective bargaining process from the unions. The arguments about disproportionate effect on women or lower income individuals, or the impact on how many nurses we have in the healthcare system, those might all be very good policy reasons and maybe good reasons why the government shouldn't have brought in the legislation. But I don't see them as being valid legal arguments as to why the bill should or should not be upheld. So at the end of the day, it's going to be a very interesting decision, whatever comes out. It wouldn't surprise me if we see a bit of back and forth between levels of the court. I think this is right on the legal line on which way it's going to go. So we'll have to stay tuned. But I think if I had to put my money on it, given our current Supreme Court composition, my gut tells me that they are probably going to find that it has violated the Charter. Which will raise an interesting question about what do you do about all the collective agreements that were settled during Bill 124. Do those get reopened again? Hopefully not. But you never know what kind of remedies might flow from all of that. In typical fashion, the Supreme Court might try to kind of cut the baby in half and say, well, okay, the past is the past, but past this point, it's all fair game and gets to be reopened, but we will have to see. So those are my comments on Bill 124. And I will now ask my partner, Jeff Murray, to come up and talk to us about the distinction between just cause and willful misconduct, just cause under common law and willful misconduct under the Employment Standards Act.
Okay, just on that Bill 124 thing, I concluded a couple of collective agreements with OPSU, the Ontario Public Sector Employees Union, and what they required or demanded was a letter of understanding that said if the Bill 124 is unconstitutional, there'll be a wage reopener. And I have to think that the reason why they asked for that is because they didn't think that if they concluded the collective agreement and the law that kind of motivated the reasonable bargaining position they had was declared unconstitutional, that they'd be able to open it up again. So I think if this is determined to be unconstitutional, unless there's that kind of mechanism there, everyone's stuck with their collective agreements. That's just my guess. Also, if it's not, I think we can expect another use of the notwithstanding clause to override that judgment. But as I said earlier today, watch this space, and we'll reconvene next year and see what happened. So I'm going to talk about one case, which is the Render versus ThyssenKrupp elevator case, and I promise that this will cause somebody either in this room or at home to gasp with incredulity. And I will tell you once I've gotten to the point where I think someone's jaw is going to drop. This is a sexual harassment case and a just cause case that was litigated in the Superior Court. And because the facts are very important, I'm going to go over them with a bit of detail. The sexually harassing employee was a man, a senior manager that had a number of employees reporting to him. The complainant did not report to him directly, but was junior to him in a small office environment. And within that small office environment, of which there were 10 men and 3 women, there was a very social atmosphere, which included employees often making sexist and offensive jokes. Some of the male employees had a practice of tapping each other on the buttocks and saying, "good game," like football players if somebody did something really cool at work. The manager similarly engaged in jokes and comments with the female employee, the complainant in this case, who was an account manager, again, who was not a direct report, but sort of lower on the overall hierarchy. This female employee would sometimes make jokes to the manager about his height, and on one occasion jokingly punched him in the arm. The appellant's jokes, the manager's jokes, were more sexualized in nature. As an example, he once asked her to bring him a clean shirt to a job site. And when she came, he was shirtless and later said, "I heard you were afraid to see me topless." And I'm just providing this to give you a sense of who the characters are here and how this workplace operated. The final incident that led to the litigation involved a group of employees and the manager joking about in the general office. The manager commented about a stain on the female employee's blouse and made an inappropriate comment about that. The female employee responded by making a joke about the appellant's height. And then, I say the appellant, the manager's height. The manager then got on his knees close to her chest and for a few seconds made a motorboat sound. Then another worker called the manager over to discuss some kind of work matter, and the general gathering dispersed. And it's at that point that the manager tapped the female employee on the buttocks and said, "Good game." Now, the court decision says at that moment, the female employee gasped and the air went out of the room. And it was clear that what had happened had gone too far, and this was a very inappropriate incident. She complains to her direct manager, and there is an investigation, and the manager is terminated. He sues for wrongful dismissal. Trial gets held. All this, on a granular level, all of these facts get explored, and the trial judge says, whether the act was sexual harassment, sexual assault, or simply common assault, the purpose seems to be the same: to assert dominance on the complainant and to demean and embarrass her in front of her colleagues. Hard to disagree with that characterization. The judge then, as he's obliged to do, goes through what we call the McKinley analysis, which is otherwise called sort of the contextual analysis, and looks at all the factors that are weighed in determining just cause, and finds that there are a number of aggregating factors. One, he's a supervisor. He's just not her supervisor. As a supervisor, he's expected to know the employer's anti-discrimination and anti-harassment policy. He expressed no remorse in a meaningful sense. He did say he was sorry, but then he denied what he had done was harassment. And indeed, he filed a subsequent harassment claim against the complainant, thinking that this is some sort of neutralizing countermeasure regarding her having in the past punched him in the arm. The judge says about the office culture, even in a joking environment, there is a line that cannot be crossed, and that line includes physical touching without consent of a sexual and private part of a person's body. Now, if that was the case, we wouldn't be talking about it, because we don't think that this case really moves the needle on the whole issue of sexual harassment and just cause. It would be one of those cases where we'd say, well, that was kind of obvious, so, on to the next thing. But the case gets appealed to the Ontario Court of Appeal. The manager appeals that the conduct did not amount to just cause at common law, and also that if it did, he's still entitled to his entitlements under the Employment Standards Act, even if there was no just cause. The Court of Appeal found that while touching the female employee's buttocks provided just cause to disentitle him to common law notice, it did not amount to willful misconduct under the Employment Standards Act. So as you've heard, I think already twice today, under the ESA, the standard to deprive somebody of their entitlement to statutory notice and statutory severance pay is what is acknowledged now to be a higher standard of, quote, willful misconduct, disobedience, willful neglect of duty that's not trivial and has not been condoned by the employer. So the Court of Appeal, female justice of the Court of Appeal, I have to say, writing this judgment, relies on this distinction and concludes that while the touching of the buttocks was, quote, not accidental, there was no evidence that it was pre-planned. There you go, your jaw dropped. Which is what would be required for it to amount to willful misconduct, suggesting that willful in this context means more than just intentional. So let's just pause here. I can't conceptualize a form of sexual harassment that's not intentional. And apparently that's not enough to disentitle somebody from a check when they've been terminated for sexual harassment. How did we get to this situation? again, we talked a lot today about this distinction in Ontario law. Ontario is quite unique, where there's the statutory test for the ESA and there's the common law test. It all comes back to a case, and we talked about this at lunch, from 2011, a case called Plester versus Poly One Canada. That case was a health and safety case where the worker had failed to lock out his machine and was terminated for cause. And the judge in that case said, not just cause, which was not we can take issue with that decision, and then goes on in the alternative to say, and alternative is just a fancy lawyer's way to, it's kind of a belt and suspenders thing, right? Like if there was just cause, he would still get his ESA because this wasn't willful misconduct, not locking out the machine. That judge acknowledged that the standards are different. And the judge in this case said that for there to be willful misconduct, the employee must do something deliberately, knowing what they are doing is wrong, and otherwise, quote, being bad on purpose, something akin to specific intent in criminal law. Now, this is what we call obiter in the law. It's statements made from a court that really aren't necessary to decide the case. And so this comment has sort of sat on the shelf for a number of years and has recently been brought off the shelf to give life to this enforceability of employment contract issue we talked about today. But this is the very first time it's actually been applied in a meaningful sense in a just cause misconduct circumstance, particularly in the context of sexual harassment. So this case is significant because it provides an example of how a single act of misconduct can justify termination for cause, but not rise to the level of willful misconduct under the Employment Standards Act. And so what we think this is going to do is make it much harder to settle cases where you've terminated someone for cause. Because if you've terminated for someone for cause and you say, well, it's cause and it's just terrible, the other side's going to say, yeah, but it's not willful misconduct. So you owe this person their ESA severance, and you may have to litigate the case. And like the employer in ThyssenKrupp Elevator, you may be on the receiving end of a decision that frankly isn't particularly well grounded in common sense and human experience. Those are my comments.
I just have one other thing to say about the Render case too. I think it's a classic example of the judge just trying to get to a result they think is fair, and then they like twist the law around to get there. Because this employee Render, he was like a 30-year employee. Apparently no prior history of this kind of thing. Single act, right? With the physical contact on the buttocks. And I think when it got to the Court of Appeal, I think the Court of Appeal was looking at it and saying, okay, 30-year employee, single act. Yes, it's just cause. I think the court, knew that sexual harassment being how significant a social issue that is now, and the total lack of tolerance for it, they had to find just cause. But I think at the same time, I think the court felt sorry for this guy and thought, oh, well, if we find just cause, this 30-year employee, he gets nothing. And then he would have been crushed on costs because the costs were pretty high. It was like a long trial. I think he was looking at $170,000 or something. And like, it was a big cost award. So I think at the end of the day, they felt sorry for this guy and they thought, well, here's this way we can maybe give him an out. And I talked to the lawyer who litigated, and he was like shocked. But anyway, and so the way to give him an out was find this wrinkle that it wasn't willful misconduct under the Employment Standards Act. And then by doing that, they were able to say, well, on the result on the appeal, it was mixed. So we're not going to crush this guy with a cost award. So what we got though is like law that it doesn't make sense. It's
it's a precedent now from the highest court in Ontario that can't be ignored.
Right.
To that argument about, oh, well, give the guy something. I think the solution to the cost award is don't be an idiot when you do something stupid and sue the employer when you're in a completely indefensible position. And if you get hammered with a costs award, well, that's your fault. The last point I'd like to make is this problem can go away tomorrow if the Ontario government simply amends the regulation to the ESA and no longer has this test of willful misconduct, willful neglect of duty, and just says the test is the common law test for just cause. And we know from my speech this morning that the government does know how the common law works and does know that it can change the common law, and therefore and what the common law tests are. So they can quite easily do that. I have to wonder why they haven't done it already. And that's it. Who's
Thanks,
next?
Jeff. Our next speaker is Ryan, who will be talking about that case that I mentioned. He and Jeremy recently argued before the Supreme Court of Canada, which, by the way, I think that was the first health and safety case heard by the Supreme Court of Canada, what, 20 years? Something like that?
Certainly the first prosecution case, and I don't even know when. It's been so long. The health and safety cases that had been before the court were administrative in nature. Canada Post dealing with inspections, and another case in British Columbia dealing with the obligations of forestry operators. Interestingly enough, of all things. All right, so talking about another case that maybe is a little bit jaw dropping from just sort of the perspective of how health and safety has worked in Ontario historically. I'm going to give the disclaimer that these comments are my own. They're not to be taken as the comments of the City of Greater Sudbury, our client. These are just our own comments and are based upon things that are on the public record. The Supreme Court's argument is available by webcast. If you want to watch the argument on the Supreme Court's website, you're more than welcome to do so. Anyone can, from anywhere in the world. All right, the facts of City of Greater Sudbury are this. The City of Greater Sudbury subcontracted a road building job. If you've been to Sudbury, it's right in the downtown area along Elgin and Elm, which is the sort of downtown area of Sudbury, which is one of the larger communities in northern Ontario, about 4 hours north of Toronto. This road building project, this company Interpaving, had a had a grader operator that was grading the road. You've seen them. These vehicles, when you're reversing blind. Like they don't have a camera on them. You can't see behind you. So not surprisingly, by law, you're required to have a signal person there directing when you're reversing to avoid the very tragedy that happened in this case. Tragically, on one day, and these facts are just, they are so tragic and so sad. It was a member of the public, an older woman who had just left a church volunteer group knitting toques for orphans, and literally walked into this construction site, which was not protected by a safety fence, was the finding of fact at trial, and was in fact what happened, and tragically was run over by this road grader. This road grader operator had what must be Ontario's worst driving record. I don't mean to make light of it, but literally his driving record we introduced at trial, which has been produced by the prosecution as part of the disclosure process. He had about 50 traffic convictions, something along those lines, and then denied remembering virtually any one of them while he was being cross-examined. So you can imagine how impressed the judge was with this particular witness. Ultimately, there were charges brought against both the City of Greater Sudbury and the contractor that employed the road grader operator, Interpaving, for failing to have a signaler, failing to have a safety fence, and failing to have a traffic control plan. I alluded earlier to a forgery involving a traffic control plan. It's from this case, in fact, as found as fact by the trial judge. But ultimately, just prior to the trial, Interpaving pleaded guilty as an employer for failing to have a signaler, and were fined as one would expect they would be by law. So Sudbury was the sole defendant, and charged in two capacities under health and safety law. One is the constructor and one is the employer. Those of you who have experience with construction matters will know that the constructor is OHSA speak for being the general contractor on a job. And in Ontario, if you're the general contractor acting as the constructor, you have to have actual authority over the work. If you're an owner of a job, like Sudbury was, who was the road authority, ostensibly owned the roadway, you have to have a hands-off approach. Otherwise, if you are seen as the owner of actually directing the constructor to do the work, you will be treated by the Ministry of Labor as the constructor yourself. These issues have been litigated over the years for decades, but the most off-cited example is a case called Imperial Oil and B&B Enterprises, and in that case, it was about building a new gas station. And there had been some concerns that from Imperial Oil about how their subcontractor was doing the job. The Imperial Oil safety rep was on the job, disciplining workers, issuing directives, and in essence, taking over the job. The Ministry of Labor shows up and says, look, who's really in charge of this job is not the subcontractor, it's Imperial Oil, not some little tiny construction company who builds gas stations. It's the big multinational oil conglomerate that sells the gas. So they're the ones that are in charge. Basically, the Ministry of Labor alleged Sudbury, who had unionized quality control officers who are employees of the city on the job, had taken steps that were so significant that they had taken over the job as the constructor. Quality control inspectors are common on virtually every construction project, essentially for the purpose of making sure that the owner is get what they're paying for. And Section 1.3 of the Occupational Health and Safety Act says that an owner does not become the constructor by employing a quality control rep. There's an exception built into that. So at trial, ultimately, the court rejected the Ministry of Labor's position that the city had taken over the job as the constructor, and further felt that even though the definition of employer in Ontario includes, like, you are responsible for everyone you subcontract for. But the court read that it is that since the requirement was that if an owner passed off, not passed off is not a good word, but it has designated liability to a third party acting as the constructor, there was no, the employer ought not to be held liable for the specific offenses on the site if they have no control over it and are required by law to have no control over it. So there's no nexus, and they cited there earlier cases had come to similar conclusions on maybe not identical facts, but similar facts, certainly. The Crown appealed to the Superior Court that just basically, in a very brief decision, endorsed the reasoning of the trial judge and said, look, that if one were to conclude the city was the employer, that would make substantially change the practice of how things work in Ontario. The Crown applied for leave, which is like permission to have the case heard by the Court of Appeal, which was granted. And unfortunately, the Court of Appeal came from my client's perspective, came to a different conclusion. The court said, look, the definition of employer says subcontracts for workers. And the court said, look, the city did have workers on the project. And that was enough that makes them an employer and makes them responsible potentially for any violation by anybody at any time on the job, which is a rather sweeping and shocking comment. And the other thing I think that's unfortunate about it is the Court of Appeals judgment ignores the fact that by following their own reasoning, you would be the employer anyway, whether you had the inspectors on the site or not. That's frankly a bit of a misleading, not misleading, but doesn't offer the whole picture anyway. So my client took exception to that decision, applied for leave, and was granted leave to the Supreme Court of Canada, which is rarely granted, less than 10% of cases that are granted to be heard by the Supreme Court. As Landon and I were sort of talking about this morning, most Supreme Court cases deal with criminal law. They rarely deal with employment law or regulatory cases like this. So the case was argued before the court. And what I can tell you is it seemed to me that there are two distinct societies of judges. There's 9 judges on the Supreme Court. A group of judges were quite convinced that it seemed that supported our ideas, that basically thought that, look, this was an unreasonable interpretation of the act. This is similar to Blue Mountain. And we argued that Blue Mountain was the case where the Ministry of Labor said you had to report the death of a hotel guest in a pool to the Ministry of Labor as a fatality, even though the person's not a worker. And the Court of Appeal said, well, yes, you could read the act like that because the reporting section says report a critical injury death of any person, but you have to read it into the whole context of the legislation, which is about workplace. So unless there's really a risk to the worker, you don't need to report someone's broken leg on a ski hill, or the death of someone in a hotel room, or the death of a patient at a hospital, or you name the absurd consequence. We made a similar argument that if we are not to be held to be, if we are required by law not to be controlling the job and not to be taking specific due diligence steps to ensure compliance, because the law says we can contract out to a constructor, an option only available within the context of a construction project as defined by health and safety legislation, what is it we're supposed to do? I mean, ultimately, to introduce us having liability is an absurdity. And I think there are a number of judges that agreed with that. It appeared from the tone of their questions. And you have to be careful. Just because a judge is questioning one way doesn't mean that's the way they're leaning necessarily. No decision's been made, and we could certainly be surprised. Another group of judges were very, very blunt, I can say, in their assessment of that. Their view was that the Court of Appeal was right. The definition makes us liable as employer because WISN, which is the Court of Appeal, is that basically if you're an employer who enters into a contract, you contract for the services of a worker, you are responsible for them. What these judges felt how our concerns could be addressed could be part of the due diligence defense. And let's be crystal clear, the Crown's position on due diligence throughout and at the Supreme Court, they openly said, look, our position is Sudbury had to take specific steps to ensure that that's at that exact moment in time that worker was being directed by a signaler. I don't think there's any doubt that in any way, shape, or form that if that were true, Sudbury would be treated as the constructor, and this concept of contracting out liability, and to an expert in construction, would be completely illusory. Because if you were required to do that, you have to take on the role of constructor yourself. Several of the justices indicated that you could assess due diligence differently, that maybe the obligations on an owner are different. And one of the comments I thought was interesting was from Justice Rowe, who is a Newfoundland appointee to the court and a very colorful judge, if you ever get a chance to see him. He just basically said, look, so all right, so I used to work at Gowling, Strathie, and Henderson in Ottawa. So what you're telling me is you can pay my old firm $500 an hour and go off to trial and hope you win on due diligence under what they're saying. Because no one really knows what it is. You're just going to have to pay a bunch of, so you're entering into what he referred to as a morass of litigation. I won't belabor the point. Lastly, we spoke extensively about most of us own a home, probably, or have, and so what happens if you have a roofer show up to your house and they're not complying with fall protection regulations and someone falls off the roof? What exactly are you supposed to do to ensure that? Are you in the roofing business? Do you know about how guardrail systems are supposed to be set up and when they're supposed to be set up? Justice Rowe raised the example, well, what about if you have some, this isn't construction, but what if you have somebody who shows up to remove some raccoons from your, he had a recent experience with that, remove some raccoons from your attic. And are you supposed to be charged if that person's not wearing the hazmat suit? Do anyone here know about what, I don't know what the safety standards are that pertain to raccoon removal personnel, shall we say? So that's sort of the frustration. That sort of is the nuts of where the argument is. So what's going to happen is one of two things. We're either going to prevail or we're not. And in which case we're going to have to go back down to the Superior Court for, I guess, a case that never seems to end to argue. It'll be our position that our client demonstrated due diligence for the reasons that we argued at trial, and getting into that's a bit beyond the scope of what we're doing today. So what's the practical implications? Stay tuned, because it may very well be, if we lose at the Supreme Court, for certain at that point, any time you contract for construction, either yourself personally or your business, remembering construction is defined more widely under health and safety legislation than it is in the sort of Labor Relations Act construction trades. Installation of machinery is by definition construction under occupational health and safety law. You're going to have this potential obligation as an employer. And if the Supreme Court says the Ministry of Labor is right, you have to establish what due diligence is in those circumstances to see if there's any way of getting out of having to require full acting basically as the constructor. If the ministry's theory of due diligence is right, then the constructor provisions are in essence meaningless. All right, so that was what I call my adventures in Supreme Court land on a rather complicated but really interesting case. We anticipate the judgment will be released. Obviously, when it is, we'll have an update on it, and either it continues or it doesn't. Thanks.
Thank you, Ryan. And last but not least, we have Jeremy to give us an update on the latest on privacy law.
All right, thanks, Landon. So you will have heard various comments on privacy during the course of the day, and I will say that Landon and Jeff and Hadi stole some of my thunder for my little privacy chat in the last 15 minutes of the day. So I'm gonna thin it down, and I'll gloss over some of the stuff that they said because they frankly did such a great job in expounding on these concepts. But what I really want to talk about here is privacy as a concept and privacy as sort of a social idea. as it's being expressed in the law, as we've been seeing. And I think that the changes we've discussed today and some of the case law we've discussed today and some of the issues, whether they be respect to COVID or vaccination policies specifically, or whether they're related to these right to disconnect policies or these duty to disclose what sort of surveillance the employer is engaged in, these are all related to sort of this social idea that somehow there's a right to privacy that is not just a nebulous concept, that it's icky to have your employer watching you and you don't know, and that you have some kind of a right, even when you're at work and supposed to be working, to do things that are personal and private in the employer, other than going to the bathroom or putting video cameras where they ought not to be, has no right to impinge on that or to monitor or to surveil. And there's this tension, I think, between the unions, the employee advocacy groups, the arbitrators and decision makers in some of the other jurisdictions that have some of the privacy legislation that Jeff alluded to, such as BC and Alberta, and in jurisdictions like ours where we don't have employment specific and applicable privacy legislation. And so in many cases, we're seeing an evolution of case law and legislation to fill in the gaps. And so I would agree with Jeff that some of these provisions are sort of a unique way, a new tool for legislating in a space where we're going to get employers to be, in my words, the bad guy. So the employer is going to be the one that says to people, you don't have the right to privacy because I say so. It's not the government that's imposing an obligation on us to allow privacy or protect privacy like it would in the Medical Information Documents Act or in PIPEDA, which doesn't apply to employment in Ontario. Instead, we're going to say, employer, you shall have a policy. And if you want to, bite your own nose off to spite your face and look bad to all of your folks, you can tell them that your policy is that they have no right to privacy and that you're going to watch everything and surveil everything, but you have to have a policy that says so. And if you want a policy that says no one has the right to disconnect ever and they must check their BlackBerry or their Android or whatever the kids are using these days at all times, then that can be your policy. But you're going to have to say that expressly and then take the hit from employee and labor relations and have people not like you anymore because you don't think that they have a right to spend time with their family and not respond to your emails. Some of the sources of privacy, we're dealing with sort of individual rights. We're dealing with the Canada's anti-spam legislation, which was announced a few years back, and then everyone was all excited about it, and then it seems to have gone nowhere. There's personal use policies when it comes to electronic devices. So, bring your own or use the company, or whether you can use the companies for your own, recordings and surveillance, and also changes to the ESA in Ontario for now. But I think that that's probably just the thin edge of the wedge. I would expect other provinces, especially ones that lean more to the left, if they can see a conservative government in Ontario promulgate these regulations, why not them? I think we're going to see some lobbying in that respect elsewhere. So Landon talked about quiet quitting and monitoring employees as a method to address the issue, right? So that was one of the sort of more aggressive ways that you might engage in surveillance to ensure performance and that people are actually doing their jobs, not just logging in and then Instagramming all day and then logging out. Jeff talked about the recent amendments to the ESA and the right to disconnect policy and the electronic monitoring policy. So I'm not going to go into significant detail about what those are. You've heard them. Again, they did a great job. Jeff made a comment which is accurate, but I don't have time to expand on in 15 minutes, okay? Which is privacy is a well-established right in Canada. This is true. But what rights to privacy in what context, that's nuanced. And in each province, there may be specific laws, such as in BC or Alberta, which took the government's lead from the federal government when they issued the PIPEDA, the Protection of Information, blah, 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 blah. I forget what the damn acronym stands for, pardon me, but essentially it's a long acronym, which means in the circumstances we prescribe, there are rules about the collection, use, storage, and consent is required in certain circumstances, and in other circumstances, you're prohibited from taking things or keeping things or sending things or using things. There are similar pieces of legislation that apply to medical documents that are applicable in Ontario, but PIPEDA does not apply in Ontario in employment. And a lot of legislators, I think, maybe forgot that. And I think a lot of arbitrators have sort of forgotten that in some of their decisions on surveillance, which again, we don't have time to get in today. But essentially, there are a number of themes coming out of the jurisprudence where in some cases, adjudicators are creating these new implicit rights to privacy that we all just sort of agree exist from nothing. They've just decided society has reached a point where this is the way that it works. Before today, there was no right to be free from intrusion upon seclusion, which is the tort that the Court of Appeal created in a case called Jones and Sieg 8 years ago now. And before that, there was no tort of invasion of privacy. That was the first time a civil court recognized that tort in Ontario. But from that point forward, if you have an intentional intrusion upon someone's seclusion or private affairs, like something has to be very significantly confidential, it must be, it must become vulnerable to that information being released in some way. And it must be highly offensive, the way in which, or the fact that you intruded upon this seclusion, such that you really should have known that would cause them anguish, distress, or harm. You don't actually have to cause harm, but if you do, you can get damages for that too. And so that tort is this general recognition in Ontario that you can't just do what you want when it comes to somebody's privacy, but the test is very high. And what you have to have done to intrude upon seclusion isn't simply looking at someone's private emails that happen to be on the work computer that they were using. So if you're getting a demand letter that you happen to have looked at that and you had to look at the email to know that it was personal before you chose not to read on, I don't really think you're going to make out a tort of doing something that's highly offensive. Now, what we've seen, though, are some class action lawsuits, primarily involving large companies, banks, hospitals, other large sector employers, who have been dealing with security breaches by their employees themselves. So an example I like to rely on or refer to is Evans and Bank of Nova Scotia. So in this case, the bank, unbeknownst to the bank, had a mortgage administration officer, that's the title, who accessed 643 client records in less than a year that they had no reason to access, and sent that information to fraudsters who then tried to engage in identity theft and were successful in some cases. So the bank gets involved, and of course it does an investigation, and it compensates people who have been affected by this identity theft, et cetera, as a good financial institution should do, but it leads nevertheless to a class action lawsuit. And so this class action lawsuit was defended initially, as most class actions are, by the bank saying, don't certify this as a class action because there really is no liability here, right? Like, in what way could we have protected from these criminal actions of an employee? There's no cause of action, so don't certify this class. And what the court said was, well, no, on the low bar of whether or not there's a potential cause of action here, we're going to say that, well, there is. And why? You had unsupervised access to highly confidential records of your clients, and that they were particularly vulnerable to these fraudsters and what they might do with this highly sensitive information. And you had no monitoring system at all as to who was looking at what files or preventing access by people who were your employees to files they had no business looking into. And so the significant risk was created between this person's wrongful conduct and the bank's operations as a bank. This wasn't something that was foreign to their business. So ironically, although we've been spending the day talking about protections for employees and rules and all these other things, I think the real issue here is, aside from a few outliers dealing with unions complaining about biometrics and cameras in the workplace or something like that, what we're really talking about are not employees suing their employers, but employers being exposed because they have employees who are engaged in wrongful conduct because of their access and their positions of trust, including cases about employees facing discipline, employees facing criminal or civil liability for the actions that they take, including a case RV Cole, which there was much talk about that, where the government had gotten the evidence about a teacher's use of a school computer in the library to look at child pornography. And the question was, well, was it okay for the police to get those records from the school, or was that a violation of the Section 8 sort of right against unreasonable search and seizure? And everybody started saying, oh, well, this means you have this right to this expectation of privacy that an employer can't violate. And in my respectful view, that's a misreading of the R.V. Cole case. So if anyone here has been read about that when it came out, that case was about whether the police can co-opt an employer to get access to information that they really should have had a warrant to go and get. That's really what that case was about, at least in my view. And it was not a case about whether the employer's network systems and devices couldn't be subject to monitoring by the employer, and if unlawful conduct was uncovered, whether or not the employer could discipline or provide that documentation to the authorities. It's not what that case stood for, but I think a lot more was done than should have been done with it. So we have this ironic exposure. I think we have an ironic solution. The ironic solution is all of these protections that the government is now introducing, these obligations to have a policy on the right to disconnect, on telling employees how you're going to surveil them and what use you're going to put to them. This is fantastic. This is exactly what you should be doing, even if these laws weren't in place at all. And the reason is a lot of the defenses that employees might raise, well, you can't use this information in litigation because you obtained it through means that were not disclosed to me in advance, and that sends a chilling effect through our labor relations if you're unionized, or in some other way it's illegal and the court shouldn't accept that evidence in a civil proceeding, even though it's probative and relevant to the issues in dispute. You have employees who have the right to disconnect, who don't need access to your systems, your emails, files and folders when they're not supposed to be working. So if you cut off their access now because you don't have a policy and they want to go and do that work, well, cutting off their access might be a constructive dismissal. It's possible because sometimes they do work after hours and you've condoned that and they need access to these files and emails and systems. If you have a policy that says after 5 p.m., because you're one of the employees who has the right to disconnect, you don't have access. You can't log in. We're going to use the system to bar you from accessing your email, to bar you from using your work computer, your work phone. You're allowed to do those things. It wouldn't be a constructive dismissal, at least as I see it, if it's a part of your policy as required by the ESA. So I think that what we need to do as employers, especially any who have an obligation, but even those who don't have the obligation to implement these new policies, is look at these as an opportunity to engage in the best practices that your counsel and HR professionals, I'm maybe sort of speaking to the converted here, but maybe for those of you who are going to go back to someone who will be making these decisions, if you don't have the power to make those yourself, you can say, Jeremy says these are best practices. Jeremy says get a labor lawyer to draft them, someone who understands the Employment Standards Act, but also who understands the realities of your sector, your employees, your operations, and can help you craft policies that will allow you to make the best use of these systems to protect you from third-party claims, to ensure that employees don't get overworked and that health and safety rules and ESA rules are respected, and that gives you the ability without the union, for example, if you're unionized, or in the civil sense, which is much harder for them to argue, trying to exclude evidence that would otherwise show that they've done something wrong because of the way in which they've been accessing and utilizing your data. So overall, I think that again, from an overarching perspective, do's and don'ts. So number one, if you are required by law to have these policies, have them. Easy, train, get them drafted by someone who knows what they're doing, or draft them and have them reviewed. We're here to help, okay? But I think you should put them in place anyways. Even if you have less than 25 employees, I think employees now have an expectation that if you are looking at them, watching them, monitoring them passively or actively, that you're going to let them know. And I think that eventually we are going to see a court that goes as far as saying that without giving that fair notice, there are consequences, whether that be that you can't rely on evidence you uncover or who knows what else, okay? So I think Why not? If you're going to do it, tell them. Advise the employees of that monitoring, right? You want them to be aware. Be clear on permitted usage and limits of any employer devices or even employee devices during working time. You want people to know if you're permitting personal use or not, what is reasonable, what is not. Set expectations clearly in policy. Restrict access when they're off work to things they don't need access to. And it's not actually that complicated these days. If there are folders that only certain people should have access to restrict access and to monitor access even by those who have that access to those systems and those files. Your IT department can walk you through that process. You want to make sure you limit access to the information that is highly confidential on a need-to-know basis, including to employee files. So guarding employee, like if you are collecting information about employees, monitoring their use, there's only certain people who need to see that stuff. And only when a red flag is raised should that go broader to the managerial community. You need to store everything securely. Not just your own stuff, but your clients and your customers' stuff as well. And also, if you have any confidential information related to your employees that would be in their HR file, HR files these days aren't always printed in a folder and in a cabinet, but the online HR file, right? I mean, that can often spread to all sorts of weird places on the server. That may create issues for you if there's an inadvertent disclosure of someone's medical information during the course of a return to work or something like that. So we need to make sure that we organize our data and we keep it securely and we restrict access. Consider proportionate disciplinary responses for people who violate these policies, but be firm. So make sure that once you've implemented these policies, even though the law doesn't require you to have a consequence for someone who breaks the policy, you should. But as Allison said, don't threaten something specific like you will be fired for cause without notice, etc. Instead, you'll be subject to discipline up to and including dismissal, and then leave it to your discretion in the circumstances and follow standard process. Don't save personal information acquired from monitoring or disclose it to third parties. My personal preference, honestly, is to have a policy which says don't use our devices or systems for personal use. If you want to have a policy that permits a reasonable amount, then say a reasonable amount as long as it doesn't interfere with your duties is permitted. But because we have to look at what you're doing to determine if it is personal, you shouldn't have a reasonable expectation of privacy for at least what is a cursory look at what you're doing. And we will make reasonable efforts not to keep looking or keep digging into something that at first glance is clearly personal. We can't guarantee we're not going to keep reading an email about your divorce or something like that if we have to open it to read it to know that it's personal. So your choice, right? If you don't like it, don't use our systems and network. And finally, don't intrude on personal use outside of work time. It's much better to have folks using their personal equipment. Bring your own device policies are a much better way to go, as long as you can consider security issues, which you don't want people putting your data or your customer data onto their devices or sending it out through their personal Gmail. So that's just something to consider on that end. But those are my comments on privacy.
Thank you, Jeremy. Well, that concludes our program for another year. Thank you for joining us. Again, reminder of our feedback questionnaires. We'd really be happy to get your responses to that. And if you do, your reward is a copy of the slides. So anyway, thank you again for joining us, both people who came in live and those joining us remotely. And we look forward to seeing you again next year. And when you have a moment, please check out our new website. And we'd also be interested to hear any feedback you have on that. Thank you.